My lord, I am from the, this is regarding maintenance matter, my lord. And he is for the, I am for the wife and he is for the husband, my lord. My learned friend is for the husband.
We have 49 number.
29.
29, 30.
Sorry, 29. I thought 49. This was just 29. So what did happen?
My lord, in this matter, my lord, regarding maintenance, he asking for reduction. I am paying for enhancement. Wife, I am for the wife for enhancement. He is for the husband for reduction. My lord. On last occasion, on 21/2, my lord, after hearing a length, His Lordship Shamima Jahan, my lord, wanted to speak to both the side directly, so that then to pass order. Kindly see the 21/2 order, my lord.
21.
21/2.
Anyway,
My lord,
see the order that it has
she wanted to speak, my lord. I do not know what in her mind, but she said that I want to speak to them. Then I will decide.
You want to say that it may be fixed before the.
If subject to your lordship's opinion,
Oh.
is it be appropriate if my learned friend is also agreeing? Subject to lordship's
Can
opinion.
it be possible appropriate court can I
Tomorrow may be done.
The assignment that also.
Then date is okay.
Because for the benefit of
What
all
the
the
thing
parties,
is,
and they are also present.
নাম তো দিদি বলি। The matter be distinct. 29 and 30, the request made by the parties that I may be listed before coordinate bench. No, coordinate bench. No, coordinate bench. This is that. Raised you will do after 1 week or what you?
Lord, he is saying for tomorrow.
No, this it is up to the convenient.
Up to you.
Yes. Both the parties otherwise.
Not my convenience because he is sitting in the DV.
Yes.
Yes.
So single bench may be there, but at present I am not in a position to say.
We are actually asking for what? They both the parties have.
Let it be after 1 week then.
My lord.
Possible.
Not possible, my lord. Only we are asking only for that, my lord. Both the parties are present, so my lord. That presence may be recorded, my lord.
But whether she is also having the Justice Jahan is also having
Yes,
single
yes.
bench?
Yes, my lord.
She is taking single bench.
Is available or not? That's my lord. That is an issue, my lord.
Yes, yes, ma'am.
But
At a 1 week of Saturday.
Page.
30.
She should have done.
30.
Mother, 3029 can it be possible?
29.
Yes,
29.
29.
29. And one more prayer, my lord. In item number 29, there is an interim order, my lord. That may kindly be continued. Item number 29, criminal petition 235 of 2021.
That probably interim order be continued in criminal petition number 235 of will next it understand.
29, my lord.
Yes.
May I please, Your Lordship? Okay, I'm praying for listing of a regular bail application for tomorrow morning.
That's the court number 8. Court number 8.
My pleasure, Your Lordship. Lordship, I beg to mention item 35. I'm mentioning on behalf of the Legal Aid Council, Your Lordship, respondent number 2. That the Legal Aid Council is not available today, Your Lordship.
Lordship, I appear for the appellant in this matter.
Have you intimated the other side, Mr.
Yes, Your
Lordship,
Lordship.
I appeared.
We
I
have taken
appeared for the
consent from
appellant.
the appellant.
Lordship, only one prayer. Lordship may grant a fixed date in the coming week because there is a IA for suspension.
So what is your difficulty on the part of MS Ghosh, the legal
She is not available today, Your Lordship.
So if we fix any date,
Yes, Your Lordship, it can be fixed.
Considering the submission made on behalf of MS D Ghosh, the Legal Aid Council for the accusation. When it can be fixed? Hearing day, any hearing day?
Yes.
5th of May.
Lordship.
Deeply 5th of May, try to go by the hearing of.
Yes, yes. Deeply obliged.
May I please, your lordship? Lordship, I beg to mention subsequent second bail application, which is supposed to be listed on 1/4, lordship. Can it
Make a
be?
mention before, may not be possible before the court number 8, so make a request before the registry.
The second
they-
bail application, lordship.
Whatever, we are not taking any mentioning matter. So you made a request before the registry, it will come before this court only, no issue.
Wait, please, Your Lordship. Item number 7, Your Lordship.
Item number 7.
7 for listed for admission. Today I have some difficulty, Your Lordship. Maybe taken up after 2 weeks.
After 3 weeks. What is submitted after 3 weeks?
3 weeks.
Request made by counsel for petition. You are Mr. Riaz or?
Zizad Ahmed. Your Lordship.
Ijad.
There's an interim order that may kindly be accepted.
Let the matter be accordingly listed to 3 weeks. As on a date to effect by the registry. Interim be continued till next.
Much obliged.
May I please, your lordship, I would like to mention item 23.
23?
Kindly adjourn this matter for the day and fix this matter after 1 week.
So 23, what is the position? You want to submit anything here? Are you on interim there?
Yes, interim may be
Now
continued.
see, the question is that charge sheet has already been submitted. We are
Yes,
continuing our interim.
My senior has some difficulties, that's why he
Today he
instructed.
has difficulty or? I mean, today he has difficulty, we can adjourn the matter, no issue.
Yeah.
Tomorrow or day after tomorrow, I mean, next Monday, Tuesday can be fixed.
Next week.
Next week. And the dates also. 28th of April, we are fixing it. 28 to 8. And
May
the
it please,
request by
Lord,
legal counsel for the
There's a long pending listed on
adjourn on 28. Yes?
there's a long pending list. It was listed on only
Which
2023
one? Which item you're saying?
criminal review petition.
No,
5
same number, say?
No, it's for admission, ma'am.
Oh, for
List-
listing.
yes.
Make a mention before court number 8.
Put by it. Obliged.
Lordship, I beg to mention item number 5 on behalf of my senior, Mr. B. Chaudhary. Due to his unavailability for his personal reason, Lordship may kindly fix a
Item
date.
number 5 for Mr. B. Chaudhary.
Yes, Your Lordship. Lordship may kindly fix a date after 15th May.
To request with the legal counsel. Mr. M. Sharma is there for the respondent. Have you informed the other side? Sorry, sir, Mr. Sarania is there, yes.
I am appearing for the
Yes,
petitioner.
yes. You're for the,
I have been not informed anyway
I mean, in criminal revision petition, you are for the petitioner.
petition. So if there is an interim may be considered.
Heard Mr. M. 524, heard Mr. M. Sarania, the legal counsel for the petition. And also heard you are Miss
Miss J. Sharma.
J. Sharma appearing on behalf of Mr. P. Chaudhary for the respondent and the request and it be requested to make for an adjournment to which Mr. Saranya raised no objection. And list the matter accordingly. After 15 May, you are saying?
Yes, Lordship.
21st of May and your interim is there? Interim be continued till next day.
Much obliged.
May I please, Your Lordship, I beg to mention item number 37, madam.
Yes,
Can it
37.
be taken some other day, my lord? In the month of May, my lord? Any date, madam?
Your lordship, can it be taken on the next week? Other on 28th of April.
You just discuss, you're for the respondent.
Yes, he's for the respondent, my lord. I'm for the petitioner.
Yes, whatever. You're saying that it should be listed in the month of May.
May, my lord. Any week, first week, my lord.
First week of May will do,
4, 5, any day.
Other than 5, your lordship.
other than 5. 7th of May is a hearing day.
7.
7.
Thursday, my lord.
Obliged.
Deeply obliged.
May I please, your lordship?
This matter is adjourned. Let the matter be accordingly listed for 7th of May.
May I please, your lordship? Lordship, with the consent of others, I beg to mention item 41, lordship. Hearing matter, lordship. Lordship, today
41.
Mr. 41, lordship. 41.
4.
Supplement.
Yes, supplement.
My lord, today Mr. Angus Counsel, Mr. L.R. Madhu is out of station, lordship.
Have you, Mr. Mahajan was
Yes, lordship. We have taken
amicus
consent.
informed.
Lordship, matter may be
Yeah,
listed after 2 weeks, lordship.
The learned counsel for the appellant. You are Mr. Islam.
Yes, Islam. On
Yes,
behalf of
Islam
L.R. Madhu.
appearing on behalf of Mr. L.R. Mujib, paid adjournment, stating that it was personally confidence Mr. Mojumdar is not available. They're allowed. Yes, you want any fixed date here?
After 2 weeks, Lordship.
After 2 weeks. Let the matter accordingly be listed after 2 weeks as on a date will fix the case.
Okay.
May it please your lordship, I beg to mention item number 4. Kindly pass over it for today and fix it on first week of May.
Item number 4.
Yes.
The request made by learned counsel for petition. Raise the issue. The matter be accordingly listed. Okay. 11th topic.
Obliged.
May it please your lordship. With the consent of the other side, I beg to mention item number 8, your lordship. In this matter, senior counsel Mr. B. Datta is appearing. Due to some personal difficulty, he is unable to appear before this court today. Can it be on 1st of June, your lordship?
When you will be available?
1st of June, your lordship. We have taken the
1st
consent.
of June. You have taken the
Yes.
of the other side? I consent of the other side. Mr. has taken the learned counsel for the appearing. On behalf of Mr. B. Datta, the learned senior counsel for an adjournment. Prayer allowed. What June?
1st of June.
1st of June is the hearing. Monday. 1st of okay.
Intend to continue, your lordship.
Interim.
Deeply obliged.
Interim be continued till next day.
May I please your lordship, I beg to mention item number 3, your lordship. I have taken consent from the other side, your lordship. Kindly matter may be fixed after 3
You are for the
weeks.
petitioner or for the respondent?
And for the petitioner, your lordship.
Your good name?
P. Roy.
Your
P. Roy.
P. Roy.
Yeah.
She will be called Ms. P. Roy appearing on Mr. Chair Allen, counsel for the petition and with the consent of the others. Wait for and requested for adjournment. They are allowed. After 2 week will do.
After 3 weeks, your lordship.
Let the matter be accordingly listed after 3 weeks as on a date to be released. Okay, 3 weeks after.
Obliged, your lordship. May it please your lordship. Lordship, I beg to mention item number 12 and 13, lordship. My senior, Mr. M. Biswas, is out of station.
Well, 12
So
and
these are all the connected matters.
connected
From
matters.
10 to 14.
9 to 14 will updated CD not received to the
You are on interim, I think.
Yes, lordship.
interim.
You are for item number
12 and 13, lordship.
12 and 13.
Will
We'll do one thing. We'll call together most probably.
yes.
All the matters.
All the
items.
matters on 5th of May, my lord, updated CD mail,
No, these are connected now.
connected matter. So all the matters may kindly be fixed on the same date, my lord. Otherwise, again, it will be
Let the other council be.
Yes,
be
yes.
hard.
yes,
Otherwise, we may fix it on 5th of May. You have not updated case I not received.
not received. matter.
So I am for the 11. Lordship, I am for item number 9, lordship.
You are for 11.
Item number 9, lordship.
Item number
9.
9.
Connected matter.
Is anyone for 10?
10.
10.
9 for 14 lots.
13, 14.
Lordship, any date after 5th of May, lordship.
Any day you want after 5th of May?
Yes, lordship. That's
Yes.
7th or 8th.
On 7th of May.
7th of May.
7th.
So what I can লিখি দিব hard learned counsels appearing for the petitioners and also hard Mr. P. Waterford, the learned petitioner DP appearing of state respondent. It is submitted by Mr. Waterford that updated case diary is not yet received. Let the matter be accordingly listed on 7th of May. Issue reminder for updated case diary. Interim be continued till next date.
Obliged.
May I please, lordship?
Yes.
Yes, I beg to mention item number 34, my lord.
30.
34. I am on behalf of Mr. P.K. Roy Sodhi, my lord. He is out of station, my lord. Respondent, Sir Tiwari is appearing, my lord.
My lord, this case is already been tagged with criminal petition number 769 of 2021 by the coordinate bench of this Honorable Court, my lord.
769.
Criminal petition 769 of 2021. It is already fixed on 5/5, my lord. My lord, there were one FIR. Initially, the FIR, GR was registered. After trial, I got acquittal. Thereafter, again, they filed a complaint petition that was also dismissed because that was also placed before the same magistrate. So he disposed of the earlier petition on the strength of the FIR. Thereafter, they filed a complaint. So both are of the same facts, my lord. So this was already fixed along with criminal petition 769 of 2021 on 5/5.
Take with this matter, my lord.
Let this be taken.
Request made by the council for both sides. Matter is active and matter may be listed on 5/5, na?
769 criminal
No. 5/5.
5/5. ma'am.
Yes.
5/5/2026 along with criminal petition number 769 of 2000.
Deeply obliged.
All right.
May it please your lordship. My lord, the FIR, my lord, is at page number 16. As per the FIR, my lord, 968 numbers of my lord plus tablets, my lord, were allegedly recovered from Sachin Kumar and Firoz Ahmed, my lord. Now, the date of lodging of the FIR was 14/6/2024. It's been, my lord, 1 year, 10 months, my lord, 677 days. Now, lordship may kindly see page number 47. 47. The co-accused, my lord, Sachin Kumar, my lord, was granted bail by this honorable court, my lord, on the ground of length of detention, my lord, because trial, my lord, was not proceeding, my lord, at a reasonable pace. And
Now you're for the Firoz Ahmed.
Firoz Ahmed, my lord. So if your lordship wants to peruse the record, my lord, then LCR may be called for, otherwise.
Your information is it here? I mean, evidence has already been recorded.
No, my lord. It's still pending, my lord.
Otherwise, this case of your present petitioner and one Sachin Kumar is under the same footing.
Same footing.
Yes, Portakur, when it can be.
My lord, already, my lord, that dispose of bail application can also be tagged. Already scan copy is there, my lord. And
Maybe, but what is the present state?
yes, on 13th of May, my lord.
It will be too late, my lord. First.
On 7th of May.
7th of May. Highly open.
Can we also be tag this? Otherwise, it will.
The up-to-date
but updated
report will
status
not be available.
Required. Call for the scan copy of the TCR along with the case diary and the present status. Registry will do 7th of May.
Highly open.
May I please, your lordship?
Yes.
My lordship, no. Your lordship, so order dated 35 is number 35, my lord.
Case number
35, my lord.
Yes.
My lord, I have filed, my lord, due to some defect in the cause title, lordship granted us to liberty to file afresh. Accordingly, this petition, my lord, filed. Well, in that case, my lord, in that bail application, TCR has been received by your lordship, called for. Allegation, my lord, the
TCR is already received.
In AB, my lord.
Your lordship may kindly peruse page 26, man.
646.
Yes.
Yes, my lord. The petitioner was failed to appear before the court. Accordingly, non-bailable warrant issued along with proclamation, my lord. That's why petitioner before the lawsuit. He is a head teacher, my lord, of LP school, my lord. My lord, he is ready to appear, my lord, and contest the case. The allegation is vague allegation, my lord. I have annexed the mark sheet, admit card, everything. In the FI, my lord, only allegation is roll number is wrong, my lord. But I have annexed, my lord, everything, my lord. Admit card, mark sheet, everything, my lord.
So allegation against you that you
Yes, my lord.
provided some false certificate.
False, my lord, in the roll number, my lord. It should be, it is, my lord, X, but in the allegation in the FIR, RX. From where RX is, my lord, found by the informant, my lord, not known to the petitioner, my lord. My lord, I have annexed the page 30, my lord. Your lordships kindly go to page 30. Page number 30, my lord. I have annexed the admit card, the original admit card, my lord, issued by the board. Clearly written, my lord, roll number X.
What is it? 26, Mr. Potakur?
26 is the order of the trial court, my lord.
Order that
It was earlier appeared or earlier he was shown as an exponent.
Not shown, my lord, in the time.
So, my lord, on the earlier order passed by the trial court on 13/6/25. So he has not appeared. It is not his ground that he has no notice about the pendency of the case.
Step, but a step
So
was
since
taken.
13/6/25, my lord, on that day, my lord, accused is also absent. No medical documents. So he is aware about the case. The case is pending since 2025.
But on 13/6,
So
my lord,
there-
step was taken by the
Since
petitioner.
then, he has not appeared before the trial court.
That's why non-believable issued, my lord, and before your lordship. It's a head my
We
lord.
are giving a next date. When is the next date is fixed?
Next date, my lord, 36, my lord. 36, 2026, my lord. 30th June, my lord.
38.
With any condition, my lord, petitioner is getting.
Let us periodic record.
Yes.
Record has
case
already
is-
received, my lord. In that AV, my lord. If your lordship take this AV,
It is there only.
yes, my lord. Yes, my lord. AV number, my lord, 646.
646.
My lord. Page number 35, my lord. 2026.
6 of 2000.
26, my lord. It was recently listed on 7/4.
You Mr. Sheikh or Alam?
T Sheikh, my lord.
For Mr. T. Sheikh, petition also for Mr. P. Bot, additional scan copy of the TCR call for full stop. However, it is submitted by Mr. Sheikh that in a earlier bail application number AB, application number AB 646 of the
Yes, fine.
the case record has already been received. In view of this, let the present bail application be tagged along with AB 646 of the rest you will do the needful.
Short
in
date.
recording. Four five.
4/5. Highly obliged.
May I please, Lord? My lord, in this case, my lord, till that we are unable to get out the registered case number, my lord. What is the facts of this case, my lord? I would like to submit here, my lord. Present, one complaint was lodged by my wife. I am the petitioner number 1 of this case. 2 is my younger brother. 3 is my younger brother's wife. 4, 5, 6 are our relatives, my lord. Since few months, matrimonial dispute going on between me and my wife. And since then, I am residing at my brother's house, which is located in my own house. And on the day of occurrence, 14/4/26, my lord, my relatives, that is accused number 4 to 6, are come from Sonapur in order to see my health condition of my oldest mother, which is 81 years old. 1 week before she was discharged from the hospital. And while they reached in front of my house, my wife and my 2 sons misbehaved with them. Then my younger brother's wife, accused number 3, and my mother went there. Some altercation took place. After that, we also gone there. Some altercation took place. After, in order to that altercation, my lord, my wife lost this present case before the Jalukbari police station. And after that, we are trying to resolve our dispute amicably, since the dispute purely within our family. But some disturbing we are faced from the police side. So, my lord, in this case, I would like to submit before this honorable court, kindly call for the record from the PS whether any case registered or not. And till then, my lord, only some protection may be given police not to take any coercive action against us, so that we can amicably settle our dispute, my lord. That is a limited interim protection I am seeking, my lord. Report may be called for.
My lord, your lordship, the present petitioner has filed 2 cases in 38 and
Yes.
39.
39 both.
One is for Jalukbari PS and another is, my lord, for Panbazar
Panbazar Women PS.
So now in which case your lordship will grant, my lord, No,
my lord, two separate, two application, my lord.
Why in both cases?
One Jalukbari, one Panbazar. You see, jurisdiction
This
was-
present petition is, my lord, Jalukbari, and item
Whether you-
39 is
whether-
relating to Banbazar.
Whether your
Mane,
lordship can grant my
your,
lord.
allegation or more or less same thing.
Same, my lord, more or less. But she has lost.
How we can call for two reports?
No, my lord, there are two cases I have filed. Item 39 in respect of Panbazar, that is, and I am at present 38, my
Now
lord.
see, the question is, Mr. Potapu, which is raised by him, that yes, there may be a case filed by your wife,
My lord,
and it is submitted rightly. It may be a matrimonial issue.
my lord,
Probability of compromise may also be there.
my lord,
We not
my lord.
But now the question is, in from which police station? We cannot call for a
No, this is
from Jalukbari also, from Panbazar also, and both these police stations will be directed not to take any coercive action. Cannot.
She has lost.
Just first tell us from which police station you need
My lord,
protection.
I'm submitting, my lord.
Ah.
She has lost two complaints before the two police station.
She cannot lose. How she will lose?
And from two police station.
Your place of residence is where?
Jalukbari, Garigao, my lord.
Then?
Garigao. She from two police station, Jalukbari police 2 times visited my house, and Panbazar police over phone is pressurizing us to appear before the PS. So, my lord, at this stage, my lord, from the 38 item concerned with Jalukbari PS.
She cannot lose two cases and
Yes,
from both the police station for the same matter.
But
they cannot come. It's just what we're saying.
Admittedly, she lost, my lord. Both police are.
Why she will lose in both Jalukbari and Panbazar?
That is Panbazar
She
women.
stays in Panbazar.
No, Panbazar women police station Panbazar, because some accused number 4 to 6 are not our family, they are relatives of ours. So, my lord, in respect of my lord Jalukbari PS, my lord, kindly. And moreover, my lord, accused number 2 and 1 and 2 are central government employees. They are serving railway department at the Maligaon, my lord, railway station. One is as a senior accountant and 2 is my lord trackman.
At this stage, my lord, I will get a report from the.
My lord, my lord. Report may be called for, my lord.
Yes,
only to that extent, my lord, so that we can, my lord, hold a meeting for settlement.
38. Also, report payment. And it's an application under 482 DNS granting period as paid to the petition. It is submitted by Mr. Ajay that out of some matrimonial dispute, the wife of the petition number 1 might have caused an FIR before Jalukbari police station, for which police from the Jalukbari police station is harassing the present petitioner and his family members. However, as the dispute is of matrimonial dispute, there is talk of compromise is going to parties, and for which some information is required so that the petitioners can appear before the IO and cooperate with investigations if any FIR has already been raised. Next person, Mr. Sir, that a report may be called for from the concerned. There may not be a case for any next getting the submission. Did a detailed report be called for from Jalukbari? No, detailed report be called for from the Jalukbari police station. So whether any case has been registered against the presentations. Further, considering the submission made by Mr. The police from the police from Jalukbari police station is thereby asked not to take any action against the petitions. They received. Let the report be called for by
on my lord 3430.
30. Are it to list 39 no order should be passed. 39 we are passing no order on 30.
Yes.
Simply sorry 39 we are listing it on 34.
But
because for same incident, we cannot call for two reports.
Police
So we are
from-
calling for from Jalukbari Police Station report
My lord.
from on 3004.
My lord.
3004 and then for 39, but simply listing it on 30 without calling any.
Malad, that is true, but admittedly, Malad, police from women police from Panbazar also over from pressurizing.
We cannot. Okay. 30. Let's go there. Another in other matter, we are asking not to take any corrosive action.
Malad. I'm obliged.
Okay.
Okay. 15 and 16.
One is PA and one is AP. In receiving
May-
case
may-
diary here.
No, my lord, item number 15 and 16. Case diary.
May I please, your lordship? 3 cases are there arising out of same FIR, 15, 16 and 27.
27 is also here.
Also, what happened? Item number 15 is a BA. Item number 16 and 27, they both are anticipatory bail and we are in interim. And regarding item number 15, which is BA, this person has been arrested. In this case, several accused persons were there. Only this person is arrested. Main accused person was granted bail on the first day itself due to the illegal notice.
Case what it?
Lordship?
Cases of what nature?
Yes, cases of extortion and some other sections are also there. Fact is that some ladies, including the arrested person and already who is granted bail, all have they have assaulted and thereafter extorted money from him. This is the allegation, Lordship. And Lordship, the item number 16 and 27, here, Lordship, all are granted in interim protection. Statement recorded, they appeared, statement recorded. The main accused is also granted bail on the first day itself due to the illegal notice. Now, Lordship, the Khobiruddin, the item number 15, he is 47 days behind the bar. And this is a sessions triable case, Lordship. And as my humble submission is that as all the accused persons are, most of them are in interim bail, main accused person is already granted bail on the first day itself, and he is 47 days behind the bar. It may be considered, Lordship.
We don't have anything.
Other petitions I am not pressing today because CD is also not there. If it is possible, Lordship may kindly grant bail.
Any short date may be fixed, my lord, I will get the CD. My lord. On my lord, 29 or 30, my lord, any date.
Short date one.
29. 29.
29.
All right, Lordship may kindly continue the interim, Lordship, till then.
That will be done.
Yes.
52 Deepak Khali.
Obliged.
The CD not received. Issue remind 29 for Koiribu. Or 16, item number 16 and 27.
27.
Item number 16 and 27. Interim be continued till next date of rating. CDB call for Koiribu. 29 in 4 Koiribu written. 16 and 27. Both in 16 and 27, we are extending their interim till 29.
Obliged, deeply obliged.
Here we have received this scan copy of this year.
My lord, the 17, my lord, TCR received, my lord.
Ah.
My lord, I need some time, my lord, go through the same, my lord.
Your lordship, kindly pass forward timing. Senior counsel is in another court.
He is also seeking time.
My lord.
With seeking time. For the timing, we have kept it. Do you want to submit anything? Yes.
The senior counsel will submit.
No, obviously, he is also seeking
Yeah.
some time. He is going through the case record.
No, he look, you can go more silent. Take it.
For timing, we are taking.
My lord, the same way, my lord, item number 19 and my lord 21. In this 3 matters, my lord, TCR received, my lord.
19 and 21 also.
Yes,
19 and 21.
my lord. 21, 18, 21 to
Who is
second.
appealing for 19?
I am 90.
He is seeking some time.
Yes.
For to
In
go
the
to
meantime, I
read
will go through the TCR.
And who is appearing for 21?
21, my lord, I will point out over here. You will probably remember in this case, there is for
For timing, you are saying this one?
Item number 21, my lord, whenever called up, I will point out.
You will address, okay.
Only my lord 17 and 19.
Okay.
Online.
18, yes. What is the
Yes.
position we have received here?
My lord, 18 case diary not received.
Not received,
Not received.
But today is 43 days, Lordship.
43 days.
And my name not in the affair, Lordship. And my lord, as per my instruction, 48 notice also not, yes, 47 notice also not charged to the petitioner, Lordship. As per my instruction, Lord. I have annexed the notice of 48, Lordship.
Case of 3102, my lord. From Gauhati.
Page 12 is the affair, Lord.
Is there any recovery till date?
Well, whether in this case earlier CD was called for earlier 7/4/26 non-appeared.
CD was not called for.
No,
No, CD was called for.
CD was called for, Lordship.
On 7/4.
Yes, Lordship. 7 was CD was called for.
Yes.
In my file, it was stated as non-appearance. my lord.
No, CD was.
Oh, no, but CD was called for.
CD in fact was not yet called for, my lord.
Oh,
Because in my file, it was recorded as non-appearance on 7/4/26.
what is the bill application number is?
Bail application number is, my lord, BA 101026.
101020.
1026. Well, any short date may be fixed. I will get the CD.
Where from it has to call for?
From Dorong district. my lord.
Hula, Lord. Hula.
Hula.
Oh.
So I'm just asking whether any seizure is there?
Seizure, Lordships. Yes, Lordship. As per my instruction, seizure is there.
No, as per your instruction, you have not furnished anything here.
Yeah, yes. As per my instruction of the section for notice for under section 47, Lord, not.
I'm not on there. I'm saying whether seizure list is there.
Seizure
Yes,
is-
Lordship. Yes, seizure is there.
You have annexed here?
No, no.
Then I want to ask you because
Not.
there is no such a hurt is caused, but the entire these things were, I mean, not stolen, but it was extorted or
Yes.
or to come some kind of robbery or dokaiti
Yes, Lordship.
was there.
Yeah.
So
That
that's
is
why I'm asking whether any seizure list is
That
there.
is true. That is true. Yeah.
So then yes,
To Kharu must spoil, Lordship. To Kharu cease from his poison, Lordship.
acha. Because as per the allegation from everything from the Godrej which was stolen away,
Yeah, that is the allegation, my lord.
stolen it extorted
Yes, Lordship.
as per allegation.
Yes, Lord. But my name not in the affair, Lordship. And my instruction is there, my lord. There is no, actually, no, there is not the.
Well, in this type of cases, how his name can be in the app?
That is true, but
Okay, then CD not proceed. Should remind me the Planet additional people will take its steps. Yes, Potakur when it can be done.
On my 4th of May.
5th of May.
5th of May, as per his. Yes, 5th of
It is 90 days offense, I think.
Yes, Lord.
90 days.
Okay, then we are listing it on 5th of May. Most way there was some miscommunication as Miss
Yes,
Parmiter, but CD was not called for. So we are calling for the sitting. Hopefully it may reach by 5th of
Time of that.
May. What is the position of 20?
20 case diary received, madam.
Is there receipt?
Case diary received. After some time.
They were not on, or interim was there. The interim was there. Can it be retained in the case diary until when it can be retained? If it has to be retained.
Then, madam.
Or we can call for again if it.
Yes. On, madam, the day after tomorrow.
Day after tomorrow means not day after tomorrow, Monday.
Monday. Then on Tuesday, madam, 20.
Tuesday then?
20.
Non-appearance on call for deputation. CD received. CD be retained till next date of listing. Listing matter on 27/4/2026. Interim be continued till next day. 28, sorry.
Yes.
21.
There's a scan copy of the
Oh,
PCR
yes.
was received here, no?
21 scan copy of PCR received, my lord. In this case, my lord, search sheet also submitted at that point of time on that day, my lord. Petitioner, my lord, objected by stating that the search sheet, the petitioner, although my lord, name of the petitioner is my lord, related with the accused, my lord, same name, my lord. But in fact, my lord, he is not the person, my lord, against whom search sheet submitted. That is, he disputed his identity, my lord, on that day. Hereafter, on the first day, my lord, your lordship may kindly peruse thereafter one report from
Yes, on the 21/11/2025, most probably, the first order.
yes.
See, in my view, it is a charge-sheeted case. So it is the best court to make an inquiry by the trial court.
Yes, only by the otherwise police is also earlier IO who was there, probably he is also now not there, already search already submitted. Now my lord, trial court has issued summons. Thereafter issuing summons, he has filed this anticipatory bail petition, and in this anticipatory bail application he again disputed his identity, my lord. So how the identity can all now, if he disputes his identity, that can only be, my lord, decided by the trial court, my lord.
Otherwise, it will be difficult on our part also, because we are
Otherwise,
not
your
in
lordship,
position to make
let
any.
him appear if your lordship can provide him any protection, my lord, interim protection, my lord. Otherwise,
He was already provided with some interim also.
interim protection, man.
Interim was there, but in one hand, it is saying that he is not the person. On the other hand, I don't know why it will be.
But father's name is different, my lord. Name of same Mofidul Islam. No, 21. So let him come, my lord.
Timing. We are keeping it on time for time being.
Yes.
May I please, my lord?
22, my lord, search sheet submitted, my lord. Please.
And now I have received lordship. The someone who is an accused person already received lordship.
Petitioner is in interim, my lord.
Yes, I'm on interim lordship.
So appear before the trial judge, then we are continuing interim for
Yes,
another 15
lordship.
days.
No, lordship, it was in the similar period. Accused lordship, protection may be granted till committal court is lordship. Similar affair lordship, other accused person.
What is it?
Protection. Same affair lordship.
It is a session tribal.
Session tribal case lordship. Yes.
Yes, it will be never ending process.
Yes, ma'am.
How you are the only accused there, or are
No,
there
two numbers of accused person lordship.
how many?
Two lordship. Father and son, yes, lordship.
What is the position of the other accused?
Other accused lordship, this order lordship. This both are received this summon copy lordship. At this receive of the summon lordship.
Both
Till
your
appearance.
son, so both father and son are shown as an absconder.
Yes, Lord. No absconder. Already I have interim order, Lordship. This honorable court has interim protection, and I have keeper. Both.
No, what is the charge sheet?
Or charge sheet. Charge sheet still.
Charge sheet submitted, ma'am.
Charge sheet.
Charge sheet is submitted. In the charge sheet, you are shown as an absconder or what?
No, Lordship.
How can you say no, Lord?
Charge sheet.
You're not sure about.
Charge sheet. This is Lordship. Not knowledge of the charge sheet part, Lordship. But receive of this amount.
Things may be there. If
Yes,
they have already appeared, you may not be shown as an absconder also. That is
Yes,
one thing.
that is.
And if you have not appeared, even after receiving the notice, then you may be shown as an absconder also. We are not in a position.
No, I am on keeper bail. I am on keeper before IO Lordship.
Yes, you are on interim.
Yes.
Whether you have appeared or not, there is nothing in our
That is correct. But at least as per honorable court order, this same affair, lordship, this protection, at least still committal court, lordship. Interim maybe.
Already interim is there. My
Yes.
The interim was there, no issue. That is not the issue. I'm just asking, we're shown as an
Yes.
absconder or
That
not
is-
absconder.
Yes.
That's correct.
What
But
is
at
it?
this stage, I have not less touched.
Hard to say that the learned counsel of the petition. So that Mr. Keyboard for learned. May be submitted by the expert, by Mr. Ford. Yes, has already been charted. Yes, yes, number.
In fact, my lord, now my lord, some of the decision I have recently gone through, my lord, probably I will have to go through in detail. If someone's issued, then my lord, he has to obey the my lord order of the trial court. He has to in person to the someone. He has to appear before the trial court
He
first.
should, he
Yes.
should.
And my lord, anticipatory
Next,
bail
that
also, my
next-
lord, at this stage may not be my lord. Otherwise, he will have to first appear before the trial court. My lord. The detail of that case I will have to go through.
There's two aspects. One is this,
Yes.
they have rightly submitted that one summon has already been issued
Yes.
against him.
And next, that
So
fixed lordship.
realizing this
15.
summon, he should appear.
Yes.
But what will be the position if he is on custody interim till committal of
Yes.
justice? It will create a confusion between the committal court as well as the committal
Yes.
court. That's the
And-
issue.
And whether he is absconder or what, that instruction is also, my lord,
Hmm.
I also have no instruction regarding that aspect.
Okay, then in
Is
that case,
this
you call
commi-
for.
I'm saying lordship, this committal court may be protection lordship. Otherwise, I will file a regular bail application, file trial court lordship.
Then how committal case, and in that case, you are not
As
going
far
to
as-
appear before the committal court.
Yes, as per someone, this offense under section, it's a trial by session lordship.
No, that
Yes.
means after receiving, in spite of receiving someone, you are not going to appear.
Yes, lordship.
How?
No,
How?
no, lordship. Will appear, lordship. Will fully appear, lordship. This I am assurance, lord.
Then what order
Before
the
this.
trial court will pass then?
Same
What will be
order.
the order of the trial court? That is the court and bench of the court. What will be the order of the trial court? What order you will pass? He has to pass some order.
But difficult is lordship, this is tribal by session. Otherwise, my interim. At least lordship.
Now see, when
Yes.
you are an interim,
Yes, lordship.
interim
Yes.
protection is provided by the High Court.
High
Yes,
Court,
lordship.
yes.
So you are on interim.
In-
Yes,
When
lordship.
interim is there, generally what court do, that
Yes.
they do not interfere because considering all the aspects, even the bail, I mean CD, the interim was granted to you.
Yes, correct.
So even if it is interim was there,
Yes,
so we
ma'am.
can extend and it will be absolute.
Yes, actually.
Now
What is the
you
difficult
just
for-
tell us,
Yes.
what order will pass by the learned trial at the time of committal?
Yes, nay.
What kind of order?
Nay, at least my bail petition is rejected. I am the paying for the regular,
No,
checking the regular bail
Already he is
application.
in
This trial
protection.
court.
Why that bail petition can be rejected by the?
They will not reject your
Yes.
bail.
Nay,
when
that
the
is-
probability is not there.
Yes, that is
But
correct.
now my question is that
Yes.
when the bench's order is there, I can understand.
Yes.
Now what order will pass by the trial court? Trial judge will have to pass some order. What
Yes,
kind
yes.
of order he will
But-
pass?
Yes, no, first of all, you may please lordship, at least not go to trial court. This is a committal court lordship. The committal court
That
cannot.
means you are not going to appear before the committal court at all.
Yes, right.
How then the court will commit the case?
Next date, lordship, may please, next date fixed for 15/5 lordship at this case. Next date fixed for, only for receive of summon copy, and next date fixed for 15/5 lordship.
No, without appearing before the committal court, how court will commit the case?
I have appeared lordship, will appear lordship, next date. Will appear lordship, next date 15/5. But I have to, checking the regular bill lordship. But that committal court cannot grant lordship regular bill my bail petition because this offense under section session tribal lordship.
What order
Difficult.
they will pass now?
My bail petition is reject and this petition is in sent to the judicial custody lordship.
That's what I'm asking. Then
Yes.
you are not going to appear before the committal
Still-
court.
Yes, lordship.
Then how he will commit the case?
No,
Unless and until there's committal
That-
court,
yes,
how will it?
no, that is you always will appear lordship on next date will appear. But at least honorable court may be at least protection
What order will pass by the trial court?
trial court.
What will be the order of the trial?
Committal court may be sent to judicial custody. The bar of the session tribal case lordship. In fact, 307-109 is there.
No, you are not putting my question. What order will pass by the trial court? Trial court has to pass some order, no?
Not committal court. First of all, this notice issued committal court, not trial court, Lordship.
That's what it, committal court.
Yes,
Yes,
Lordship.
now he is the trying.
Yes, yes, yes.
Unless and until it is committed.
Yes,
So
Lordship.
what order will be passed by the committal court?
Committal court, at least is then when Lordship, this present petitioner is appear before this committal court, immediately I have this seeking the regular bail application. But the jurisdiction of the committal court, there is no
The silver order will pass.
reject. My bail application is reject, Lordship.
Well, extending your 15 days time. Heard Mr. Editor, so you say that cases are already been served. What is this charge sheet number? Yes.
CS number, my lord, 111/25 dated 30/12/20.
111/25.
Dated 30/12/25.
15 days action. Or we can do one thing.
Yes,
It will take time or maybe 1 month or 2 months. I don't know. We have to call for the case check. That is the only option. Otherwise, no order can be passed by the learned trial court or the learned from committal court. What order he will pass? It is not in a position to pass any order on committal. Has to pass, you are on bail, you are on something. Has to pass some order.
That is
the-
my lord, that is correct. But
Because we
Honorable
come
court
from the
may
trial
will
court,
pay our
so we
lordship.
know what will be the position of the trial court or the committal court. What order he will pass? He has to pass some order. What order he will pass? You are already under protection.
Yes.
We are extending your protection. So generally, what the court will do in a committal case, if you are not on interim, suppose, then in the court case there may be a probability of not granting you a bail.
Yes, ma'am.
But when you are on interim,
Yes.
in that case, the committal court will generally pass the order of bail because it is not a case that you
Yes.
cannot pass the order. You
Yes.
can pass the order while you are on interim. So that order can be passed, or you have to wait unless and it is, I don't know when the committal case will be tried by this something, then we will call for the case, entire case record, and then the order of your absolute bail or anticipatory bail can be granted in that case.
Yes, may I please lordship, 15/5, the next date fixed for 15/5, within 1 month, lordship. next date fixed for 15/5, lordship. Appearance, huh? That many trial court of my appearance. No,
No, we have to call for the case record.
Okay.
Okay, then in that case, we'll call for the case record. Right? 30 February 2025, full stop. Considering the submission made by learned counsel for petitioner, let the scan copy of the TCR be called for along with the case diary. And your next date is 15/5.
15/5, lordship.
Before 15/5, any date can be called.
My lord, on 12/5, ma'am.
Okay, 12/5. আৰু আগুৱাই দিব পাৰে ন? Let us say for a bit.
Yes, ma'am.
Before 12/5, any
Before 12/5 also, my lord, on 6/5.
we're listing it on 6/5.
Yes.
But hopefully, I don't know whether it will come or not because trial court is not yet committed. Nah. Anyway, we're listing it on 6/5. Interim we continue till next day.
Interim may be continued, lordship. Deeply obliged, lordship.
20.
For your lordship,
Yes, 24.
Mr. Gogo is is on legs in some other court, lordship. Timing.
Timing.
May I please the lordship. Herein, the petitioner, two is the father, one is the son.
Question of 25. 25 plus as Mr. Botakur, you're saying the 25 or
25, my lord, substitute submitted.
Interim is there, your lordship, and they appeared here.
heard Mr. A.M. Khan, the learned counsel for the petition. And also heard Mr. P. Botakur, the learned additional PP being on it is submitted by Mr. Botakur. The case has already been charged sheeted by CS number, yes.
CS number 71/26 dated 21/4/26.
Dated 20?
21/4/26.
21. Next para, it is submitted by Mr. Khan that the accused petitioner had already appeared before the IO, cooperated in the investigation after obtaining the order of interim rearrest. However, as case has already been charged, the petitioner is hereby asked to appear before the learned trial court with a regular application for bail, which may be considered in accordance with the interim granted to the petitioner be extended for 15 days from the date of this.
26.
Well, 26 also search sheet submitted, my lord.
Well, I am on interim, my lord. My lord, one point is there, my lord. My lord, the case is yet to be committed. It is a sessions tribunal, my lord. That's the problem. If I appear, my lord, before the magistrate court.
See, that is the problem. We are
Yes, my lord.
what I have heard. Now, problem is with the committal court also. How case will be committed?
Yes.
Is the only issue. So generally, what happens if you are on interim? Interim means you have already granted bail by the apex court. I mean the high court or by the session judge, whatever. So you are already in interim. In that case, generally what happens? Generally, that protection is given or the bail is granted. It's not a case that the in a session tribunal, all the session tribunal, the court cannot pass any order on bail. Definitely it can be passed because now what is happening if you are suppose police bail, it may be a 302, but if you're on police bail, so when you appear before the trial court below, someone should you appear and your regular bail is automatically order has been passed.
All right, can I pray, my lord? Until someone is issued, my lord, I may be protected.
Someone is issued, I don't know. Someone is issued means not yet issued.
Not yet issued, my lord.
How can this protection? Yes, Botakut, can it be any?
Or your lordship may keep pending, my lord, because today I have seen the argument, my lord. I will try to impress upon your lordship, my lord, on the next day. After a week, my lord.
The request made by learned counsel for the petition. The matter be listed. After 1 week, any date. 4th of May.
4th na lage 5 tarikh. 4th is the election counting, my lord. I'm off. Interim will continue, my lord.
Yes, interim will continue.
I'm off.
28 also, my lord, search sheet submitted. No?
In this case, you are not on interim item.
No. But this year may be called for.
No, it is you are not in even on interim, na? How can we this year be called for? We'll dispose of the matter with a direction. If suppose in that case subsequently if appear or the appear or adverse order against you, you can approach this court. Or subsequently also you can approach the court. No issue.
My lord.
You are MS?
PM Ahmed. PM Ahmed.
PM Ahmed, the learned counsel for the petition, also heard Mr. Keyboard. And it is submitted by Mr. Porter. That case has already been translated. Yes, CS number?
CS number, my lord, 24/26, dated 16/4/26.
In view of this, the petitioner is hereby asked to is hereby directed to make a regular application. Directed to approach the learned trial court below with a regular bail application, which may be considered in accordance with the above observation and if it stands. Okay, we'll see.
Please, your lordship.
Yes. You have received case diary?
Case diary received, my lord.
Are you on interim urgent?
We have appeared, lordship. In terms of an interim bill, we have appeared before the IO gave our statement, lordship.
Yes.
The allegations are of 318, 19, 38, 36, and 40. FIR is at page 15, lordship. I am not the named FIR accused. FIR named accused, some 3 others.
Yes, whatever as per him,
Yes.
he was not the.
He is not named in the FIR, but my lord, I would like to point out to your lordship, my lord, this is a case of initially, my lord, name of the accused persons in the FIR, Rahul Alam, Aminul Islam, and 3 Anwar Hussain, my lord. And that allegation is that an amount of rupees 20 lakhs was credited in the bank account of Rahul Alam, my lord. And thereafter, my lord, during investigation, my lord, one bank account, my lord, police has, my lord, seized the my lord, here in the case, there is bank account of police has collected bank account of Firdous Alam and the present petitioner also, my lord, and he appeared, my lord, his statement recorded, my lord. I would like to one, my lord, bank account, the petitioner, present petitioner, your lordship, Mufidul Islam. He is the owner of, my lord, one Krishna clothes store, my lord.
This present petitioner.
Yes. During investigation on 20, it was found that 20 lakh was transacted from Tezpur so-and-so Killer Krishna clothes store to Firdous Alam Yes Bank account. So that amount of rupees 20 lakhs was transferred to the account of Firdous Alam, the present accused number 1 in the FIR, my lord, from that bank account. And that owner of that bank account is, my lord, Mufidul Islam, the, my lord, present petitioner. My lord. And my lord, during investigation, it is found that a total credited amount of rupees 3 crore 2 lakh 74,000, 3 crore and 809 rupees have been received in Firdous Alam bank account. One of the accused, my lord, main accused number 1, Firdous Alam's bank account. There are more than bank transaction of more than rupees 3 crore, my lord. And during investigation, they are all involved in, my lord, all these, my lord, they collected all these, my lord, amounts by way of cyber, my lord, fraud. Your lordship, my committee, your lordship may kindly peruse the statement of flag at Dios, no? Oh.
Lordship, during investigation, mostly they will not find anything that any amount has been included, fraud amount has been deposited in my account. The allegation is against Firdous account.
Not only.
Secondly,
yes,
secondly, Musa Ali, he is the informant here. He is nowhere the victim. He simply, the affair says, I have heard that some amounts have been deposited in the accounts of the FI named accused Rahul Alam, Firdous Alam. I am here a innocent person. I have transferred some money for my personal purchase of lands, etc. Lordship. Not with the no investigation that I have collected any money. That is a fraudulent plea, and I have transferred or any conspiracy with Firdous Alam, Lordship. Here the Musa Ali is not the victim. Nowhere that yes, my money has been, because this is a case of cheating, personal impersonation. 420, 419, 467, 468. No document that any of his documents were fraudulent, coerced by this particular informant here, petitioner here, Lordship. Some 3 crores, 4 crores, maybe of the in the accounts of Firdous Alam or Rahul Amin, Lordship. I am nowhere connected with that part, Lordship. They have to prove that yes, I am involved with some victim should be there. That this petitioner Mufidul has collected money from us, cheated us. Most probably, she will not find anything, Lordship.
My lord, first of
So
all,
I am ready to cooperate, Lordship. I have already appeared before the IO.
my lord, first of
And
all,
this is a case of
Musa
lordship.
Ali may not be a victim. My lord, FIR can be lodged by anyone, and thereafter, my lord, investigation, my lord, during investigation, police has found that although initially the name of the present petitioner is not there, because yes, my lord, from the bank, police has collected those, my lord, bank details of Firdous Salam, and from that bank details, a huge amount of rupee transaction, that is more than 3 crore. Thereafter, a statement of Firdous Alam is also there. They are not doing anything, my lord. And from his statement, although, my lord, he specifically stated that all these amounts were transferred to his bank account, and those amounts were transferred from the killer, my lord, that name of that bank account, that is, that account holder is the, my lord, Mofidul Islam. And from Mofidul Islam has, my lord, transferred all these amounts here. Mofidul Islam Alam's statement is also there. And not only the statement of the Firdous Salam, other material during investigation also, my lord, now in his statement also, my lord, Mofidul Islam stated that I am is the holder of that bank account, although he is trying to shift the burden to other accused persons, my lord. All these accused persons trying to shift the burden in the same manner, but huge amount of, my lord, money transaction is going on in their account, and the present that account from where 20 lakh amount as mentioned in the FIR is transmitted to the account of Mofid, to the that account to the account of Firdous Salam as mentioned in the FIR. That account is also, my lord, of Mofidul Islam. That is, my lord, Mofidul Islam statement also, he admitted that that account is of mine, but they, my lord, use
But
that.
the main allegation to by cheating by cybercrime, I mean, whose account from those monies were
Those that in the FIR it is mentioned that an amount of rupees 20 lakhs, my lord, initially transferred to the account of Firdous Salam. But in his statement, Firdous Salam stated that that account was transferred to his account by Mofidul Islam, the present petitioner. And thereafter, during investigation also, now he stated in his statement also that I am is the owner of that, my lord.
Some clothes store.
Yes, that clothes store. And from that account, these amounts were transferred to the account of Firdous Salam. And Firdous Salam he has also stated that those amounts were transferred by Mofidul Islam, and they all, my lord, received commission from Covid. After committing those cyber offenses, those amounts were transferred to these accounts. And for, my lord, in this their statement, they stated that for that we obtained, my lord, commission. And for this transaction, Firdous Salam has stated, I have received that commission of rupees 4 lakhs from Mufidul Islam, from the present petitioner. His statement is also there, Firdous Salam's statement. And, my lord, later on, my lord, after recording the
that this cybercrime, or how the persons were cheated or the money were defalcated, how
but during a police has found that there, my lord, bank accounts were also, my lord, sought for from the bank has also provided huge amount of monetary transactions is going on in
and from whose account those were transmitted or the
transmitted,
cybercrime
my
was
lord,
committed?
regarding those, my lord, investigation is still going on, my lord, from where those, my lord, monies, my lord,
So there has
transmitted
to
to
be
their
some persons
accounts, because Morigaon district, my
through
lord,
cybercrime, one
yes, huge,
accounts of some accounts has to be there. This kind of thing.
yes, these are investigations still going on in that respect.
For those, Lordship, those are documentary evidences. If at all to be collected from documents only. Whether custodial interrogation is required, I have appeared, I have given my statement, I have never forced anything, Lordship. I have never suppressed anything. Whatever my statement, I have given honestly, Lordship.
But it is the case of the other accused fiduciaries that entire money.
So, co-accused
20
statement
lakhs,
cannot
20
be number one co-accused statement.
No, entire 20 lakhs was, transacted from your account to
Yes.
account of one fiduciary.
Yes, one account, one transaction, Lordship, there. We are not denying that part. Bank transactions are permissible, Lordship. They have to collect that. Yes, I have collected some money from somebody else. That is not there, Lordship.
You will have to disclose that source from where you have, my lord, obtained that.
That is
amount
not
of
there.
monies.
Let them investigate.
lakhs.
I am ready to cooperate, Lordship.
So
With
investigation
any
is-
condition, Lordship, I am ready to cooperate.
So
There is
without-
no chance. I am a businessman, Lordship, having a shop.
I'll just record your permission. I'll pay you.
Yes, ma'am. Otherwise, without custodial, my lord, interrogation, this type of offenses, my lord, those things, source, my lord, and everything, where from those amounts comes to their account, it will not be, my lord, it would be difficult for the police to.
This is a case of 2025, Lordship.
Heard Mr. S.K. Poddar, Learned Counsel for the petition. Also heard Mr. P. Waterford, Learned Additional PP, appearing on behalf of State. This is an application under section 7 in connection with Next is submitted by Mr. Potter that disseminate petition is not an FINM accused. And he is not be connected in the arrest of he after obtaining the order of interim pre-arrest bail dated 23/03/2026, he already appeared before the IO, cooperated in the investigation, and his statement is also recorded by the IO. He is still ready and willing to extend his cooperation if he is granted with the privilege of pre-arrest. Mr. Poddar further submitted that though an FIR was lodged by one Musa Ali, but there is no allegation to whom any cheating was committed by the present accused petitioner, or as to how the cyber crime was committed and cheated any person in that regard. However, he is ready and willing to extend his cooperation in the investigation. Next, Mr. Botwood, Illuminate additional PP submitted in district that after obtaining the order of interim period bail, the petitioner appeared before the IO, and his statement is also recorded. But from during the investigation, it has come to the knowledge of the accused petitioner that the present petitioner is a owner of a clothes store, and an amount of 20 lakhs was transacted from his account to the FINM accused to the FINM accused Firdaus Alam, and it is also found that in the account of Firdaus Alam there was transaction of more than 3 crores 2,74,000. But the investigation is still under process, and from the statement made by the co-accused person, it is seen that they are trying to shift their allegations from one accused to another and giving the same kind of statement. To stop, however, it is the fact that 20 lakhs of rupees were transacted from the account of the present petitioner to the one of the main accused, Firdaus Alam. Mr. Botwood accordingly submitted that investigation is still under process, still under continuing, and hence his custodial interrogation may be necessary for the purpose of investigation. Accordingly, he raised objection and submitted that it may not be a fit case to grant the pre-arrest bail to the present petitioner. I have recorded your submission. I'll pass the order.
Yes, sir.
Obliged.
I will flag mark some of the.
Yes, that's what I'm.
Yes.
I'm sorry, Lordship. What about Lordship?
21.
21. I'm sorry, Lordship. In this case, Lordship.
My lord, my prayer before Lordship already he is under interim protection, my lord. While he has, my lord, raised, my lord, dispute regarding his identity already under protection. So let him appear before the trial court and raise the dispute regarding, my lord. Otherwise, also, my lord, those IOs who were earlier, my lord.
See, the question is that
Yes, ma'am.
You are disputing your identity.
Lordship.
So we may not be in such a position to make any order or make any inquiry in that regard. It may be difficult on our part also.
Lordship.
Because we have to record the statement of the IO, whether he has visited the place of occurrence, whether any person naming in a similar kind of name or the identity may be there or not. These things are to be inquired with.
Lordship.
And my lord, from the FIR, my lord, it reflects that, my lord, who has lost the FIR, he can identify the, my lord, accused person. Because, my lord, regarding some agreement between them regarding for purchasing of a, my lord, vehicle, my lord. So if, my lord,
obviously,
you
are not the person.
he can identify.
Your agreement was not with you then, in that case. Then there may not be any agreement with you if you are not the person.
Yes.
Then so what we will do, yes, Mr. Botapur, we can ask to approach this the petitioner before the learned trial court below, and learned trial court below may make an inquiry.
Yes, well.
And till the completion of inquiry, he may be under
Yes,
interim
yes,
protection. That
yes,
may be, that kind of order can be passed.
Yes,
I may be
Otherwise,
protected.
how we will do?
Yes.
Now, IO has to be called for, it has to be recorded, his
Yes.
statement. These are the things to identify,
Yes.
to for your identity.
Your lordship may fix a particular date, my
protected
lord, ask
lordship.
him to appear before the trial court on that day, and my lord, then trial court, my lord, can
And
inquire to the
he is the only sole accused shown as the
sole accused, my lord. And
sole accused.
an informant can identify because there is agreement between the parties for my lord purchasing of a my lord vehicle, my lord. If informant comes, he can identify.
During
the
CC, my lord, it
accused
can be
person.
considered by the learned trial court lordship. During CC.
Go for CC. Prior
Yes.
to that,
Prior to
you're not supposed to, I mean, prosecuted by anyone
Yes.
if you're not the person.
Loss.
If you're the person, then obviously, if you're not the person, then there should not be any further prosecution.
This is a judicial order lordship. There is judicial order of the learned trial court lordship.
Yes, where is
That Gauhati was also there lordship. He said that no such person is there in by this name lordship.
already inquiry was done by the learned trial court.
Yes, lordship. Honorable, my lord, as regards the notice issuance of notice, kindly see page number 19.
Page number 19.
My lord, page number 19 lordship. Order dated 14/11/2019 lordship. The report is endorsed by the Lord Gauhati. Seen the report, Sashit and accused is an absconder. Have been shot. Summons issued lordship. Summon issued to the accused has returned with report that the accused was not found in the mentioned address. It could be learned from the local people that there is no people by this name at that area. The report is endorsed by the Lord Governor.
It was order was on basis of the summon only, not
My lord.
Yes.
Yes, this regards.
inquiry.
the inquiry was not done.
I am also my lord disputing. No, I am also disputing that I am not that.
Because of
You
his
said that
yes.
is your
Yes.
case.
Yes, Lord.
I can understand.
Now, I may be a protected law. I will PR. I raise my. I will raise my
You
lord.
did anyway.
And try
Yes,
to
lost.
Inquiry may be done.
yes, yes.
Lost.
Heard Mr. M.H. Emmett, the learned counsel for the petition, and also heard Mr. Report for the learned petition. What was we called for? We called for the
TCR, Kajari and my report of the my lord OC, Lalo PS.
have
Lalo,
you received
nothing but
TCR?
yes.
No.
No,
TCR has already been
TCR already received, my lord.
TCR, Gauhati case has already been received. But it is submitted by Mr. Portfolio on only on perusal of the TCR or case report. The inquiry in regards to the identity of the present accused petitioner may not be possible. May not be possible. May not be possible at this stage. In that context, Mr. Amit, the learned counsel of petition, submitted that he is a naughty person, and he is naughty person, and it is the mistaken identity under which the present petitioner was called by the under which the summons were issued to the present petitioner. However, the summons already returned unserved to the learned trial court below with a report from Gauhati that no such person resides in that locality, and the summons returned. But as the NBW had already been issued against the present petitioner, he had to approach this court with the present bail and the secretary bail applications. Next one, considering the entire facts and circumstances of this case, it is seen that the case of the present petitioner is that he is not the person against whom the FIR was lodged by the informant, and only on the mistaken identity the summons were issued against him. Next, after considering the submission made by Learned Counsel for Books, seen that the trial court will be the best court to make an inquiry in regards to identity of the present accused petitioner. Present accused petitioner accused. And the informant may also call for to that regard to identify the present petitioner as to whether he was the person with whom any agreement for purchasing the vehicle was entered by the informant. Next para, in view of this, the learned trial court below is hereby asked to make an inquiry in regards to identity of the present accused petitioner as to whether he is the person against whom the FR was lodged by the informant. However, till completion of the inquiry, the present petitioner will be protected. An interim order passed against the present petitioner will be continued till the completion of the inquiry. But the present petitioner is hereby asked to appear before the learned trial court below as and when he was called for or the date fixed for any inquiry. Time limit can be given.
Yes, also 1 month.
1 month.
From the date of the date may be fixed for appearance of the petitioner before the trial court. Yeah.
And the learned trial court below is also hereby directed to complete the process of an inquiry within 1 month, and the petitioner is also hereby asked to appear before the learned trial court below as and when the date is fixed for inquiry. Okay.
A date may be fixed for appearance of the present. Otherwise, he will not appear after before the trial.
Yes.
No, 1 month.
One
1 month maybe I have to communicate loss.
No. On 12th
No,
of
1 month within 1 month
Yes.
it's to complete the inquiry procedure. So you may appear at a date some side you.
On 12 or 13th, he can
Yes,
appear.
12 or 13.
12
may
or
appear
13
before the
before the
learned
trial.
trial court below on 12th of the 12 5 to 20. With the above observation. Let them inquiry, your interim will be continued.
Loss. All like that.
Katamati board.
24.
Petitioner appear before IO recorded his statement.
So here in this case, Lordship, the person is involved in taking money for the against job, Lordship, and sufficient evidence are there. But Lordship, his statement is also that note I have given got that I know that his statement is being recorded, but that statement I have not found. So let that statement be called for, Lordship. In the meantime,
You are not appear?
Appeared.
he appeared. That note I have got,
Statement
but that
also
his statement what he has stated that I have not found, Lordship. But otherwise, the materials are against him. The city.
He admitted that before IO that he signed as a witness in Dolil.
But his statement is not available.
Not available. That may be called for.
Card Mr. We did only counsel for the petition, also card Mr. Yes, law for the learned additional PPA. And this submitted by Mr. Gogo that after obtaining the order of interim arrest bail, he already appeared before the IO and cooperated in the investigation. Next paragraph, Mr. Lawford did an additional PP submitted in this. That it is from the note of the IO, it is seen that the petitioner appeared before the IO, but his statement is not available in the case diary. And hence he submitted that an updated case diary may be called for, along with the statement of the petitioner, if already left. Next, in view of this, let the updated case diary be called for, and I will also hereby directed to furnish the statement of the present accused petitioner, if already recorded, and the petitioner is hereby asked to appear before the IO within 7 days from the date of order, if the statement is not recorded by the IO. Not recorded. And let the matter be listed. 11th of May, so and so. Interim be continued till next year. If your statement is already there, I may asked the IO to furnish the case statement. And if in case suppose statement is not there, then you appear and your record is there.
And
11th of May.
at least on 19th May, item number 36, Lordship, it's come at the hearing, bill against acquittal.
Acquit against acquittal, na?
Yes, Lordship.
Other side, Mr. P. Das, Mrs. MS P. Das is appeared. Then amicus.
Amicus curiae was appointed. It's not earlier.
You're for the appellant.
Yes. So 19th May, Lordship, I will be.
The hearing. Request by appellant. System, the transaction, the matter be accordingly listed 19th of May. So it's on the hearing list. Okay, we're listing it.
Oblige.
Pending item 17.
The scan copy of
Yes, it has already.
this was called for, my lord. I mean, it is a charge sheeted case, my lord. More than, my lord, 131 days under jail custody, my lord. It is a suicidal case, my lord. His wife, my lord, lordship. And my lord, he has a ailing mother, my lord. There is none to look after, and also small boy, my lord, 2.5 years, my lord. So, my lord, I think there is no any impediment. If the bail is, he will face the trial, my lord. Already 131 days under custody, my lord, jail custody, my lord. So, lordship may kindly consider, because he is also under CD charge sheet. It has been mentioned that, my lord, she has some psychiatric problem also, my lord. So, earlier they did not file any FIR, nothing, my lord, regarding dowry torture, my lord. The allegation is that due to dowry torture, she was mentally suppressed and committed suicide, my lord. There is no such clear that there is a abatement by the husband, my lord. And other family members who are not arrested, my lord. There has been totally released from the, my lord, charge sheet. From the charge sheet, they are not charge sheeted. So my that has been committed to the session judge, and session judge lordship will find rejected a bail. Ground is that, my lord, in page 35.
Page?
Page 35. From 34 it is started. 35 is the relevant portion, my lord. Only said that, my lord, I have considered the rival submissions. I have also gone through the case record. On perusal of the same, it found that charge sheet has been submitted in this case. In view of the above, as well as the considering the nature of the alleged offense, bail prayer of Gautam Rai is rejected, my lord. No any other ground that there is some incriminating materials has been found or not, my lord. So my prayer is that, my lord, she may be allowed to go on bail under any condition. He will appear before the trial court. Face the trial, my lord.
Yes, my lord. Here, my lord, date of offense is, my lord, 11/12/2025, my lord. And FIR is lodged on, my lord, 12/12/2025. Now, my lord, there is the brother of the, my lord, that is the deceased, my lord, woman, my lord, lodged the FIR. And in the FIR, they stated that, my lord, there's kind of, my lord, harassment and all things are there. I have flag mark, my lord, that is the PM report, along with the, my lord, after that, my lord, there is a chemical analysis report that is there, my lord. The viscera was taken, my lord. And my lord, there is a suicidal, my lord. That part, other parts are there, my lord. And I have flag mark, my lord, there is the statement of the, my lord, that is the accused also, and also, my lord, that is my lord, that is the informant, my lord. Other than that, my lord, there are other witnesses are there, my lord. 24 numbers of witnesses are there, those who are the, my lord, neighbors, my lord. And my lord, now the case is already being committed, and my lord, next date is fixed for, my lord, search framing on, my lord, 5th of May, my lord, 5/5/2026. That is the position of the case, and as on today, my lord, 132 days in custody, my lord. But search yet not framed. Though, my lord, FIR, when it is lodged, my lord, it is, my lord, lodged under, my lord, 82, my lord, dowry date, and but, my lord, the search sheet is, my lord, given under 108 PNS, as abatement of suicide.
Charge sheet was filed on 108.
108.
108.
108. Abatement.
It is that is abatement but suicide.
Abatement of suicide. But when
not
it is
dowry.
lodged, my lord, that time, my lord, it is 82, my lord. That's dowry date.
Dowry. Yes, madam.
Initially, when, my lord, the FIR was lodged.
Dowry torture.
That is the position, my lord, but the search yet not framed, my lord.
A small boy is there, my lord. And now he is, that boy is also without mother and father. So, my lord, there is, his father is also not alive. So, other brothers are, no brothers, sisters has already been married, my lord. And only
his age old 75 years old mother is there, my lord. So considering all these aspects, your lordship may kindly consider his regular bill.
Heard Mr. S. Not, that's all. Given number 7, heard Mr. S. The learned counsel. Also heard Mr. Yes, sorry. He was the learned additional PPA. And this is an application under section so and so in connection with so and so. City receipt. Sorry, this scan copy of the DC along with the receipt. Next one, it is submitted by Mr. Nanded with the necklace petitioner is innocent and he has not committed any such offense as well as India. However, it is a fact that the victim was suffering from something wrong. Now, of which she might have committed suicide, but the petition is not connected here. But it is submitted that though the India there is some allegation of dowry, demand of dowry, but no FIR was earlier lost by the informant or the victim in her act alleging any further submitted that there is none to look after his only child and the old ailing mother. Hence, considering this aspect also, he may be released. He is already behind the bar since last 130 days, and case has already been charged. Hence, there is no the case has already been charged, and hence there is no question of or temporary any evidence of the prosecution arrest. However, he will regularly appear and will contest the case if it is granted the privilege of it. Next, but Mr. Also, the learned additional PP submitted industry that from the PM report and the cell report, this is and that the case is of suicidal death. And he further submitted that initially the case was registered under Section 8 BNSS, that is the dowry debt, but subsequent to the investigation, after investigation, the case is charged under Section 108 BNS with the allegation of suicide. He further submitted that the next date is listed for framing of charge on 5/5/2026. Until date, no evidence has been recorded. No evidence has been recorded by the prosecution. Further submitted that there are as well as 24 numbers of witnesses whose statement were already recorded. Most of the witnesses are the neighbors of the accused petitioner. Next, hearing the submission made by and the case diary. Considering all these aspects of the case, including the submission made by the counsel for both sides, vis-a-vis a length of detention already undergone by the accused petitioner, I find further the custodial detention may not be required for the purpose of trial. In view of this, the witness to whose satisfaction it has to be.
My lord, this is additional, my lord, session just FTC Sri Bhumi.
To the satisfaction session. 50,000.
Additional session.
Okay, you are granted bail.
Last. Blessed.
No, 19 is dealing with
My lord, Mr. Locker has, my lord, gone through that. He's on another court matter. He's coming, my lord.
He is coming.
Yes.
For admission, item number 6.
Yes.
For the respondent who is appearing,
My lord,
you are
I am appearing for the respondent, sole respondent. And I do not want to file any objection because only two questions they have raised regarding my lord service of notice and my lord security sake. There is no concept of security of service of notice also duly served, my lord. I think that criminal petition, my lord, without any reason they have filed without any ground, my lord.
Lordship, this matter would require a hearing, and on the last occasion, they sought time to file an affidavit, Lordship. On the ground, Lordship, I was anticipating that they would be filing one today. I'm not as such prepared for the hearing today. Lordship may fix it on some other date.
so you are not, you have not filed your any written reply.
No, my lord, don't
It's
say,
not
my lord, any reason is required, my lord. Only two basic ground, my lord. There is a security checks. I have paid 10 lakhs, 7 lakh 10,000 for a one vehicle. Then they have given me the check of 10 lakh 10,000. Then I have deposited in the bank, it will bounce, my lord. This is a case, my lord. They are saying this is a security check. So
Lordship,
security check, maybe when they have paid, I'm keeping the check. That can be a security check. No, there is no concept of security check under, my lord, NIA. Even then, my lord. So that second part, my lord, only two grounds they have challenged what I understand, my lord. The notice has been not duly served. That cannot be a ground, my lord. It will be trial court to decide whether notice has been duly served or not. When the notice goes to the proper address, as per section 27 of the General Project, it deemed to be served. If address is proper, whatever notice they have issued, whatever is the agreement, their address is shown, that address I have issued the notice.
That is a registered address.
That's the registered address. This is a company, they may remove the sign also, who knows? If their address is there, this is the place, I have issued down that address, the notice, deemed to be served.
Lordship, I will satisfy on that. However, there was on record, the trial court had recorded it was returned without being served, but it was considered as deemed served. There are now decisions of the Supreme Court, wherein it has been said that when it is returned without being served, that cannot be deemed to be considered as deemed to be served. That I will satisfy your Lordship on the next day, Lordship. Lordship may kindly fix a date.
Then, my lord, I will possibly file the vote. So if they take a date, my lord, I thought today will be heard the matter, so there is no necessity of filing the.
No, Sidi, that may be difficult because she is just now, the council has submitted that they were under impression that you will be filing the written objection. You will be filing written objection. For that reason, they thought that one written objection copy will be served and the written objection will be filed today. But that has not been filed by you, so you make your submission through oral submission. Okay.
So that because they are enjoying the stay, my lord, last 2 years.
Last 2 years.
Not 2 years, 25, it is filed.
Earlier also they came for transfer. That means so that time they got the stay. The transfer petition has been, my lord, dismissed. So ultimately 2 years, my lord.
Yes.
Case of 2023, my lord, 26.
It has to be seen solely on the basis of the case that has been filed here, Lordship. It is in 2025.
Your name?
N. Begum.
RMS N. Begum, the learned counsel for education. Mr. Saronia, the learned counsel meeting number 1. Submitted by Mr. Saronia that they are not going to file any written objection and will submit orally. And in that context, Ms. Begum submitted that she needs some more time to go through the for argument, as they were under impression that written objection will be filed by the other side. Maybe of this, let the matter be. Yes, any fixed date? Want any fixed date here?
And not any that time I not.
Any month?
Maybe within, my lord, week.
Month of May or April?
May, Lordship.
My lord, they will be after 4th May, my lord.
After 4th of May.
May, my lord.
Oh, after election.
My lord.
I mean counting.
My lord, counting. So let's see the reaction also.
The
maybe
only
2
day of
days.
thing is 4th. Yes. Hearing day. 12th of March is the hearing day. We can fix it up.
My lord, my lord.
Sorry, 12th of May. In the meantime, it is your thing. If you want to submit any, then it can.
My lord, I'll file my.
Should I press in the if the response?
If required, file reply, my lord.
Huh?
I will file.
If is that
Not reply objection, my lord.
File written objection.
Lordship, interim may be extended.
Same time be extended till next date.
Much obliged.
My lord, that what maybe if required, my lord, because others again they will take, I will see, my lord, whether
No, you are at liberty, you may file, you may not file. It's no
my,
issue.
my
Item number. In one default.
Your Honor, FR is in page 18, case of recovery of
It is a
fixed current.
charted case.
Charted case, charges frame, and it is in evidence stage, Your Honor.
FR is at page
Page 18. 28, 28. Yes.
28.
Mm,
No, where is the FIR? FIR.
FR is page 18, Your Honor.
80.
Some fake currency were recovered from his shop, Your Honor. That is the case. And fact is that he's a 51-year-old person, having a reputation of humble person. Everyone from his neighbor and of his society came up in his support. I have submitted and annexed the statement of his neighboring shop owners and other social organization in support of his character and his behavior. He's a 51-year-old person having no criminal antecedent so far. And in this case, all the persons, neighboring persons have stated that in his absence, some persons who came to his shop when he went to collect his gas cylinder, Your Honor. And that persons kept those currencies, and subsequently police has come and recovered that currency. So it's a case of false implication. And fact is that they are during investigation, they have not taken any independent witnesses. All the witnesses are police witnesses. And in fact, except that recovery of currency, nothing has against him. Your Lordship can come to the page number 26. 26, that is particulars of witnesses. All these witnesses are police witnesses, Your Honor. That is 1 to 6, all are police witnesses and officials, Your Honor. No independent witnesses are there. And Your Honor may see the page 27. In point number 6, they have said the analysis, the forward and backward linkage of the accused person committing the offense, but no clue has been disclosed. So there is no linkage found against him, whether he has collected that currency from some persons or he is supposed to give to the other person. Nothing has been found, no criminal antecedent. So at this stage, Your Honor, on the ground of, and admittedly, Your Honor can see is page 57, Your Honor. Your Honor, this is the statement of his neighboring shop, who may be could be a witness, independent witness, but police have not taken any such witnesses of his neighboring locality, Your Honor. Here in point number 6, they say that the real fact is that on the fateful day on so and so, the accused person opened his shop as usual, and I also opened shop at the same time. Shortly thereafter, the accused called me to his shop and informed me that he booked a gas cylinder and today he would be going to collect the gas cylinder from the agency, and he requested me to look after his shop in his absence. That accordingly, the accused left to the received gas cylinder at 12:30 p.m. and instructed me to supervise his shop. Sometimes at that time, my co-partner of my shop was also present. That in the meantime, two unknown person arrived at the premises on one motorcycle which had no registered number plate, and they did not remove their helmets, thereby concealing their identities, and entered in the shop of the accused person, and I could not prevent them from doing so. I was attending the customer in my own shop. After my customer had left, I noticed one stranger was carrying a black color plastic bag which he placed on the rack inside the shop of the accused person. Thereafter, I asked them what they required and replied they wanted cigarette, and I informed them that the same was not available at that time, that the said accused person did not leave the shop until the accused returned. Upon his return, they asked for Sikhar, and accordingly, accused person gave them the same which they wanted for. Subsequently, a team of SSB personnel suddenly arrived and surrounded the premises and entire shop and subsequently recovered those currency. So my humble submission is that at this stage, when evidences are due, so if he would get a fair chance to defend his case, then there is ample probability that he can defend his case, because these witnesses of his neighboring persons and other witnesses are also giving their statement. I have annexed those statements, and other organization of his locality, they have stated that he is a very humble person. He's a very quiet in nature. He has no criminal antecedent. On such occasion, if he would be given a fair chance to defend his case, then it will be fair, I guess, Your Honor. So that is my humble submission. At this stage, he has already been behind the bar for 70 days, Your Honor. He was arrested on 8 to 26, Your Honor. And all the witnesses are police witnesses, so there is no chance that he can disturb the witnesses, because all are the police witnesses, everything was seized. So there is nothing that he can hamper, Your Honor. So at this stage, my humble submission is that he may be allowed to go on bail and defend his case in trial, Your Honor. That is my
So these that statements they have read out lordship is their statement also. This is it could for আপনি এখন statement and proceeding affidavit দিছে. It is on the basis of affidavit. So we'll go by the 162 statement. And as per 180 statement lordship, that when police personnel, SSB personnel went there and they have seized the 210 numbers of 500 rupees FICN currency. So lordship, it's in huge quantity. And when person himself was there, at that time he was there, and it was recovered from his shop. So there is every possibility that he was dealing with that currency. So only because that some neighboring persons has given some affidavit that he is a genuine person, that maybe lordship, because a person who is doing such kind of any business in such kind of business, his face is always clean in the face of the society. So we will not go by the statements of the other persons who are not the witnesses or not the witnesses of the in the search sheet lordship. So we'll go by the search sheet lordship, and it is not that lordship only because that there is no any independent witness, the case will be acquitted. Because lordship, today I'm not I'm trying to recall it. There is a judgment also regarding the seizure witnesses, that when it is stated lordship that in absence of any seizure witnesses, independent seizure witnesses, case should not be fated. Because what happened in this case, it is applicable because one person is something is recovered from one person, and his neighboring persons are very good relation with him. So now neighboring person never comes forward to give signature against him. So this is sometimes it happens. So only on the reason that he is not the no independent witnesses are there, his case will not go. So at this stage, lordship, he should not be released on bail, because this is not a simple and not a simple case. It's an heinous crime, because lordship, fake currency. It's a crime against the nation, we can say.
Except the recovery of the currencies, is there any other instrument?
No, because it was kept in his shop. It was not that let's say he was preparing that currencies. This is not the case. He was dealing with that currency, and he is and he did not state anything about that currency. That yes, his statement is there that I may read out. My name and address is stated. I am a businessman and I have my stationery shop at Komartoli under Simla PS. Some amount of FICN are kept in my stationery shop. Today, SSB staff along with Dumni of outpost staff arrived at my stationery shop and recovered FICN notes and apprehended me. They brought me to the Simla PS. That's are enough from my side.
He has also stated that were kept in his shop. He was not.
So how one person's in a person's shop, some such a high huge quantity of notes can be kept by another person. He has not stated, he has not stated here that this was not kept by me, it was kept by someone else. He has stated say it was kept here. So Lordship, when those notes are recovered from him and it is in a very initial stage, trial is not yet commenced, only the search has been framed and no witnesses has been are being examined. So at this stage, Lordship, that may not be allowed, Lordship.
In this connector,
Because
your
Lordship,
lordship
the
also
crime
can
is in
see.
such a nature that which may hamper the entire financial system of our nation, Lordship. It's not a, it maybe it's only 1 lakh rupees, but it's 1 lakh, it may it will be go to the crores and crores rupees.
Your lordship may also see the page 70, Your Honor. That is the statement of the complainant, Inspector G.D. Nauren Keso Singh. Fourth line from the bottom, Your Lordship. Examined the statement of the Soilan Goswami, but he could not reveal anything. So they have examined, they have also not found anything from him, Your Lordship, except the recovery of those notes here. So my humble submission is that at this stage he may be given a fair chance to defend his case here.
In judicial, in custody
Because
also he will get the chance. He is now also he is
because all
such a
witnesses
good
are
counsel
Your
also,
Honor,
Lordship.
police personnel, no independent witness, so there is no chance
You
that he can.
Mr. Saikya?
Yes, yes, okay.
Hard Mr. U Saikya, the learned counsel. Hard Mr. P.S. The learned additional PP beyond the application section so and so. Scan copy of the picture and maybe case edit. See, next subject by Mr. Saikya, the present petitioner is, and he is a very humble person and known by the entire. He had no criminal incident earlier, and he is also implicated. It is a fact, the fact that some fake currency note was recovered from the shop of it, from his shop house, but during that period, he was not available in the shop. He was going to collect his gas cylinder when two unidentified person came and kept the packet with the fake currency in the shop. And immediately after his arrival, the police came there and the fake currencies were recovered from his body. We further submitted that the person from the entire locality had made this statement regarding his innocence, and one of the shopkeeper, one neighboring shopkeeper also sworn an affidavit stating as to what had happened after his what had happened in his absence. In his absence, when two unidentified person gave the packet in his shop. So we further submitted that all the witnesses are of the police person, and the petitioner had no chance to was not given any had no chance to defend his case, and if the present petitioner is allowed to go on bail, he will get the chance to arrange his defense witnesses to prove his innocence. More so, the case has already been charged, and as all the witnesses are of police personnel, there is no chance of tampering with the witnesses. Next part, Mr. Lawford, the learned PP submitted in that the charge sheet was filed on the basis of on the basis of statement made by the witnesses under section 180 ANSS, and the statement and the affidavit sworn by a neighboring shopkeeper may not be relevant at this time, at the present time. Post of further, he submitted that in absence of any other scissor witnesses, any other independent scissor witnesses, the evidence of the police officials or the police official or the official witnesses cannot be discarded. He further submitted that being the neighboring people, there is less chance of adducing any evidence against the present petitioner from the person of that. Mr. Lockwood further submitted that the case is very initial stage and the prosecution is not yet examined any of the witnesses, and hence bail may not be granted at this stage. Next, madam. Hearing the submission made by Land Council for I have also made a scan copy of the DC. Considering all these aspects of the case, and also considering the length of detention already under the this court is of opinion that further hospital detention may not be required for the purpose of investigation, for the purpose of trial. Accordingly, I find it difficult to extend. Due to whose satisfaction this is?
Session Judge Baksa.
Baksa. With satisfaction of session judge. Session judge?
Yes.
It is session tribal. Session judge Baksa. Okay, you are granted.
Yes, obliged.
What is it? Akrati one?
May I
Is
please
the I criminal with AB? With is what is it? I is what is for I? I is for?
Lordship, here in this case, we have filed IA for bringing on record certain subsequent development pursuant to filing of AP, Lordship. Actually, Lordship, under presumption, we filed the bail application without PS case number, Lordship. But later on, we came to know that PS case has been registered, Lordship. So we filed
you have
this
filed
IA.
your FIR.
Yes, Lordship. And
When the AB is fixed in when? Date? Otherwise? 23rd of?
yes, Lordship.
Today is the date fixed.
Yes, Lordship.
Oh.
And another IA, we have also filed that one, though it has been disposed of by order dated 30/3/26 for modification and correction of order, Lordship.
Next date is 23 for today.
And in the main case,
It is
CD
fixed for,
case,
CD
case
and
diary and postmortem report has been called.
today it was fixed for CD lots. CD we have not received today.
Along with
And-
postmortem.
Along with postmortem, Lordship.
But if CD do not come, postmortem will not come. CD and payment report it was fixed. CD we have not received.
So why the other interim? It sounds interrelated. It was done through VC, I think, na?
He is an interim Lordship, probably.
Yes, Lordship.
Petitioner is an interim.
So your case number was
Yes.
Yes, Lordship. PS case number.
But
They-
after correction, have you called for the case diary? Most probably not yet. Because it is
They did not they did not mention the case number Lordship in the petition.
Acha.
That is why they are going to bring this FIR into the record also.
And the petitioner has appeared before the IA also. Statement has been recorded, Lordship.
It is not good. But they are seeking some modification. What modification?
It's what kind of modification do you need?
Modification, Lordship, actually, PS case number, we have not mentioned in the main case. That's why an order 26 to 26
What
order
happened,
was
Lordship,
passed.
probably what happened, Lordship, instead, as they have not mentioned the PS case number, that is why that order has been passed without giving the PS case number.
Yes, yes.
So probably
Yes.
they may,
Yes.
now they are going to incorporate that order, that PS case number in the order.
It be dispute PS case number
132, Lordship. 132/2026.
I think you are MS?
KLR Yantan.
Ini mas kosong nota video.
K and R and
Order nomor gimana sih?
proceed. Return it out to the applicant.
Before that, we will check, Lordship, because of what order earlier passed.
Actually, what are
No, it's on
initially
in
they
IA
prayed for
331.
a interim protection, stating that the dispute police station any case may be registered. And while the hearing was taken place at that time, they submit before us that it was dispute police station 186 has already been registered. Accordingly, order was passed in that regard. Subsequently, one IA was filed stating that it was not dispute PS 186, but
Yes,
dispute
Lord,
PS 130.
Then-
Accordingly, that order has
I
been
am
passed,
submitting the-
modifying the earlier order, that is wherein police case number was fixed, written as dispute 186 instead of dispute 1832. That was there. Now they have filed this IA to bring the
On
dispute
record.
PS on record 132. That is the main issue.
Only on the cross title of
Is
the
there any other modification you need? No.
No, Lord.
Lord Passport blah blah blah. It was gonna say the order Passport was now that.
So and so, this interlocutory application has been filed by the applicant. Petitioner only to bring in record the FIR which has already been registered under dispute PS case number. Dispute PS case number. Open qualification.
Lordship 132, public 26.
I don't know why you have filed these things and what is this? What is I? For filing, you see what you have written. Okay. Have you gone through the I application in
My lord, yes, my lord, the
What
two
is
numbers of IA, one, my lord, FIR, they, my lord, in present IA, my lord, 314/2026, my lord. Present IA, my lord, they annex, my lord, one, my lord, there is the FIR, my lord, page 18, my lord, of the IA. So,
the cost title again 186.
yes, my lord, only an additional affidavit is, my lord, by bringing the same, my lord, only additional affidavit is, they can file, my lord, and brought the things before this honorable court.
And this see the prayer, what is there in this prayer in 186 again, it is mentioned as 186. You're just confusing the code itself, na? What is this? Correction
Yes, my lord, the prayer portion is something different, my lord.
One.
Table four. First.
Again,
Actually,
they have to
Lordship.
see again confusing the code again 186. They have actually what do you want?
Actually, Lordship, we have first filed this IA
After that only the second IA.
No, sir, no. In the first IA, Your Honor, Lordship, our PS case number was wrongly stated as 186/2025. For rectification of that mistaken statement, so we have filed another IA. And in that IA on 33/2026.
314 from deep a
সেইটো অৰ্ডাৰটো ভুল হৈ গ'ল এই পিএছ কেছ নম্বৰটো ভুলকে লিখিছে
If we pass any order here in your 314, it will again create confusion. Better to dispose or withdraw this one.
Yes, and finally, original repeat file koi didiyo.
Here you have mentioned 186 only, this poor 186. What to do?
No, for that we have filed another IA.
So now why you are pressing this one?
No, we are not pressing it. It has become infractuous, Your Honor. On IA 331.
Considering the order passed in IA criminal 331 of 2026, it is seen that the present IA has already become infractuous.
Yes.
Accordingly, the same has been disposed. IA 331, I had to dispose with AB to deal, hard so and so and so. It is submitted by Mr. Comfort that question that you have not received the case diary, na?
My lord, we have not received the CD, my lord.
CD
We pray for a short accommodation.
So and so. In view of this, the additional 50 is hereby asked to issue remand to the IO to furnish the case diary of case diary of this full PS case number 132/2026 along with PPF.
Yes.
Interim was there.
Yes, Lordship, interim order may be continued.
Estimate determinate.
Interim আছে
8 of May.
Yes.
Can it be, my lord, the 12th, my lord? 12th of May.
12th of
It's all become confused because of filing of 2 IA.
Very cool.
For hearing item number 32.
Is the criminal petition.
Yes, no, no, no. The court has had called earlier, trial court record, it is not received yet. Charge sheet also has been filed in this case.
No, TCR not yet received, man.
Date may be fixed.
Earlier, the CD was called for or what?
No, charge sheet submitted, my lord. Thereafter, scan copy of TCR was called for.
Oh.
Scan copy not yet received. The last office note dated 21/4/26. 21/4/26 office note.
21/4/26. Last date.
Yes, last office note dated.
Office note, sorry.
Office note.
Only 22. Vote or not? It would be vote for. So when you have filed the criminal petition at that time, it was not charge sheeted.
During the pendency, charge sheet was filed.
Charge sheet was. You are Mr. Your good name?
G. Kaushik.
G. Kaushik.
G. Kaushik.
Card Mr. G. Kaushik, you learn it for the card Mr. P. Boy, you learn it additional PPA, bringing up state response. It is submitted by Mr. Waterford that during the pendency of this case, the case was already charged. And a scan copy of the detail was bought for, which has not been received by the registry. In view of this, later reminder being issued, calling for TCR. TCR, from the concerned trial court in connection with Gitanagar PS case number 137 of 2017, registered under section 294 by 507 IPC, read with section 67 of IT Act and section 3(1) clause Roman 10 of schedule cast schedule pract bracket of prevention of item for order dated 3/2/2025 supplies. Registry will continue to it has to come from here a yare Gitanagar. Come
14.
14.
Obliged.
Yeah, my facility.
May it please your lordship. There is an appeal, your lordship, against conviction of 10 years under 376 IPC. Basically, your lordship, the case here is that the petitioner has a love affair and there was a promise to marry and there was a FIR filed against rape on the ground of promise to marry. This is basically the case. Lordship will take the paper book. Paper book is there. I'll take your lordship to page 4 of the paper book.
Yes, page 4.
Page 4 of the paper book. This is the FIR. May I read? I have the honor to state that I have been in love with the below cited accused. We had been in love for about 2 years, and the accused has promised to marry me. The accused has committed rape on me by applying force and defiled my chastity. Now the accused is trying to marry another girl while saying that he will not marry me. The accused has betrayed me, deceived me, and committed rape on me. The accused is a BSF Jawan. I therefore pray to you to take necessary against the accused and others. So basically, this is the fact. It is an admitted fact that they were having a love affair, and since the petitioner has broke off with her and is going to marry another person, she has filed the FIR on the ground that it was a promise to marry and rape was committed on her. Now, your lordship will have to go through basically the evidences. I will just point out. And my case is on the fact that from the most first point that will come up is that she refused medical examination. Secondly, your lordship, this was a consensual physical relationship that continued for 2 years. And after 2 years, your lordship, when the person wanted to marry some other girl, then she filed their FIR against him. And your lordship, in fact, the mother of the victim did not support the victim's case. I'll come to all these. And they stayed in hotel as husband and wife. In 3 or 4 times, they have stayed in certain local hotels and have remained there as husband and wife. And she's not a young girl, your lordship. She is about 25 years at that point of 27, 28 years at that point of time, as per her, your lordship, report. And your lordship, mainly the judgment that was passed was on the ground of presumption and so these are basically the grounds which I'll be taking in this. So first, your lordship will kindly turn to page 8 because this is the evidence of the girl. Yeah, I'll just read that here because this is, since it is her evidence, I have to read it. I know the accused present in the dock, Jagadish Burma. I am the informant of the instant case. I lost the written FIR against the present accused, Jagadish Burman at Tespu PS. Accused is brother-in-law of my maternal aunt Potimara. There was marriage of my maternal aunt Potimara in the year 2015. And to attend her marriage, our entire family, comprised of my parents, myself, and a younger brother, went to Kuch Bihar. And in the marriage, accused himself introduced with me After stay about 2 weeks at Bihar, we returned to our home at Tezpur. At that time, I was studying in higher secondary first. Accused somehow collected our mobile number and thereafter made calls over phone, and initially my mother received the call and had talked with the accused, who used to address my mother as Didi. Thereafter, once accused made call over our phone, and as I was holding the phone, I received the call, and the accused given his identity as Jagdish Burman. Then I apprised him that I was available in college, so not in a position to talk to him. Since thereafter, accused started talking with me over phone very often, and therefore a friendship developed between us. Thereafter, once accused proposed to come to Tezpur for a pleasure trip, and accordingly he came to Tezpur without informing me in the year 2017. After arrival at Tezpur, accused over mobile phone informed me that he has already reached Tezpur and as such asked for assistance. Thereafter, myself accompanied with my friend Pinky Ray went to Kekorapul and brought the accused to our residence. The accused stayed one day at our residence and thereafter proposed to take me to Kuch Bihar at their residence for a pleasure trip. On the next day, I went to the accused to Kuch Bihar, believing him in good faith, being brother-in-law of my maternal aunt. The parents of the accused lived in separate house, whereas my maternal aunt and her husband lives in another house at a distance. At night, the parents of the accused went to the house of the maternal aunt, Fatima Ray, to stay there for the night, whereas myself was kept with the accused in the house where the accused and his parents generally lives. In the meantime, a love affair grew between me and the accused. On the night itself, the accused promised to marry me and forcefully committed rape on me. The subsequent day, accused brought me to my residence at Tezpur and thereafter he returned with assurance not to worry, but he will marry me. At that time, accused was serving in Shillong as BSF Jawan. After a month, that is on so and so, accused takes leave for 1 month, came to Tezpur and boarded at Hotel Register, and there from he has called me in the room of the hotel, and on my reaching there was false pretext to my parents. Accused given me a tablet as safety measure from pregnancy, contraceptive pills, and thereafter kept me in the said hotel room for 2 nights and maintained physical relationship with me. The accused given my identity as his wife in the hotel for keeping me with him. Since thereafter, accused very often used to come to Tezpur from Shillong and stayed with me as husband and wife, thrice in hotel register and once in hotel your room, twice in hotel Uruka, so and so, so and so, being the last stay together as husband and wife. I took paper from of court marriage and asked the accused for solemnization of the court marriage, but the accused with the pretext that he has some problems at his residence. After overcoming the problem, he would marry me, and thereby he declined to put signature in the forms of court marriage, and the accused sought 1 month's time for solemnization of the marriage with me on the ground of construction of a house at his residence. At that time, I was reading in HS second year, and accused told me to appear for exam, and after completion of my exam, in the meantime, his house would be constructed, and thereafter he will marry and take me to residence at Puttiha. After appearing 3 papers of my SSI, I came to know over phone from Kuch Bihar that the accused went on leave for 2 months and staying at Kuch Bihar, looking for a girl for his marriage. Thereafter, I made phone call to the best friend of the accused, who is also BSF Jawan and was serving at Shillong, and he knew about the relation between me and the accused. From the friend of the accused, it was confirmed that the accused went on leave for 2 months and he was looking for a girl for marriage. On such confirmation, I went to Shillong headquarters of BSF to meet the commanding officer of the accused. I could not meet him because he was not available at station at that time. As such, I returned to Tezpur and went on the house of my friend so and stayed there for the night. On the next morning, I once again went to Shillong and met the commanding officer of the accused and apprised him about the details of the incident. Acts and accused with me, and the CO allowed me to stay there for the night. The CO in the meantime called the accused in the headquarters. On the next morning, the CO inquired about the veracity of the fact and the accused in my presence. The accused produced some fake documents before the CO showing that he has already married someone. As the accused has already married, the CO have advised me for approaching law enforcement agency for legal recourse against the accused. Thereafter, I returned to Tezpur and lodged Zahar against the accused. So and so is Zahar. Police recorded my statement. Police produced before the magistrate for recording my statement, and accordingly I have given my statement before the magistrate. Is my statement given so and so. Now cross, your lordship. While I lodged Azhar against the accused, I was aged about 25 years. At the time of lodging Azhar, I had one mobile number and my mother had her separate mobile phone. On the date of lodging ejahat, the love affair between me and accused was of the tenure of 2 years, 3 months. There was well conversation between me and the accused. Because the accused is the brother-in-law of my maternal aunt, so with permission from my guardian, I went with the accused to Kusbihar. At that time, there was cordial family relation with us and the accused. At that time, accused was serving as BSF. I do not know whether accused visited Tezpur with his official work while posted at Shillong. At first, accused committed rape on me forcefully. Thereafter, he promised to marry me, and on such promise, I continued to live with the accused whenever he asked and maintain physical relation. As the accused pretended that he had already married before the CO, so the CO told me that he can ask for accused for payment of money to me as compensation for settlement, but I did not agree the said proposal of the CO. I informed of the incident of the case, the local panchayat of the accused, but nothing yielded. It is not a fact that I have stated alike of today before IO. Police with medical requisition took me before doctor for medical examination, but no medical examination was done, followed by a discussion between the doctor and the ladies police official who took me to the doctor. While I tried to give evidence of the conversation between me and the accused in respect of our affair, the accused broken down my mobile phone, and as such the call details are not available with me. It is not a fact accused did not propose to marry me. It is also not a fact I have deposed falsely to the rest we can see.
Yes.
I will not read all the depositions. Two, three depositions are not required because ultimately cross was also declined in those cases. So just those which are required. PW2, your lordship, page 12 of the paper book. I know the accused, this is a mother. I know the accused present in the dock, Jagadish Burma. Informant victim, Anima Ray is my daughter. Accused is brother-in-law of my own sister, Potima Roy. There was marriage of my sister Potima Roy in the year 2015, and to attend her marriage, our entire family comprised of husband, myself, my daughter, and my son went to Kuch Bihar. After attending marriage of my sister, we returned back to our home. After about 4 months of marriage of my sister Potima, once accused made phone call to me and told me that he intended to come to our place. Accused being our relative, I could not refuse him. After 1 day of making phone call, accused arrived at Tezpur. Accused stayed for the night at our residence, and in the night, accused proposed to take my daughter with him to Kuch Bihar for pleasure trip. Although I refused the proposal of the accused, but somehow forcefully accused took my daughter with him to Kuch Bihar. From Kuch Bihar, my daughter informed me over phone that the family members of the accused became annoyed on the fact of taking her by the accused at his residence. As such, I asked accused to bring back my daughter, and on the 4th day of the accused brought my daughter back to the residence. After some days, I came to know that an affair between my daughter and accused was going on, and following by the relation, they used to talk to each other. My daughter, with a pretext to visit the residence of her friend, used to go outside our residence on many occasions. Subsequently, when my daughter lodged Ezahar at police station, I came to know that with the false pretext of visiting friend's house, accused and my daughter lived together in the hotel room at Tezpur. I also came to know that accused kept my daughter with him in various hotels, giving my daughter identity that of his wife. My daughter told me that accused proposed to marry her, and with a promise to marry her, the accused maintained physical relation with my daughter, but subsequently did not marry my daughter. Now cross, your lordship. My daughter is presently aged about 27, 28 years. My husband is alive and he is a e-rickshaw driver. I believe accused being our relative, but if he developed love affair with my daughter, it was beyond my knowledge. While we went to Kuch Bihar for attending my sister's marriage, there only accused came to introduction with us. Accused altogether came twice at our residence at Tezpur. I have not seen with my eyes that accused and my daughter were living together in hotel room. It is not a fact that I have deposed false. Now, your lordship, PW3. This is the hotel manager of a particular hotel. This I am not reading because in this hotel, the accused was staying alone. It has been stated that the accused was staying alone in that hotel for one night. So this doesn't have any sense of reading, your lordship. Then PW3, your lordship, also, PW3 I'm not reading. PW3, no, PW4, your lordship, will come. PW4 is the hotel where they live together. That is 17, page 17. I know accused present in the dock who has lived at our hotel, Hotel Metro, with his wife. The Hotel Metro is situated at Mojid Road, Tezpur. I was serving as manager of Hotel Metro continuously for 4 years and left the said job only during the lockdown of the nation in 2020 because of expiry of my parents in the pandemic. So and so, I was serving as manager of Hotel Metro, Tezpur. Today I bring with me the daily register of Hotel Metro of the year 2017 in compliance with the court's order. Exhibit so and so is daily register of Hotel Metro. According to Exhibit 4, it appears that on so and so at about 2:30 p.m. one Jagadish Burman, accompanied with his wife Onima Rai, came to our Hotel Metro and asked for a room for their stay. Accordingly, I have allotted room number so and so to them, and they stayed together in said room for 2 days as husband and wife. P4 is relevant entry on so and so, whereby room number so and so has been allotted for stay of Jagdish Burman with his wife so and so, is the signature so and so so and so so. Again, on 22/8/17 at 7 p.m., the said Jagadish Burman and his wife Anima Rim came together to our Hotel Metro and for stay, and I being manager of the said hotel allotted them room number so and so, and they stayed together as husband and wife in the said room continuously for 3 days. This is relevant entry in Exhibit P4 relating to room number so and so so and so. The daily inmate register is prepared in duplicate. That was now cross examining. Both Jagdish and Anima went together to our hotel, and Jagdish Burman asked for allotment of a room in our Hotel Metro for stay with Anima Rai, giving her identity as his wife. Both of them have given their identity proof, and thereafter the room has been allotted. The identity proof of Jagdish Burman and his wife so and so were sent along with inmate register to the particular day of the stay in our hotel to the concerned PS as record of daily inmates. There's nothing much to state with regard to this. Here is only one thing, your lordship. They stay in this hotel twice. Once for 2 days, one for 3 days. And in fact, there was not a single whisper against rape or something in this case. They came and stayed like husband and wife. Now your lordship will kindly turn to PW5. I am not reading because nothing is there. PW6 also I am not reading, nothing is there, your lordship. Let us go to PW7. You. He is the ASM of police. That is page 22. Page 22. On 22/3/2018, I was serving in the capacity of ASI Assam Police and posted at Lalmati Police Outpost. On 19/3/18, one Anima Rai lodged a written azar with the then OC Tezpur, namely so and so, who on receipt of the azar registered Tezpur PS case number so and so and 420/376 and endorsed me for preliminary investigation on the case. On being endorsed, I visited the residence of the victim, recorded the statement of the victim and her mother, and thereafter sent the victim for medical examination by issuing requisition. Thereafter sent the victim to the court and got her statement recorded under 164. Subsequently thereto, I made search of the accused and came to know that at that time, accused was serving at 60 so and so East Khasi Hill, Shillong, Meghalaya. And as such, I sent as many as 3 WT messages to the accused asking him to appear before me in connection with the case, but the accused did not turn up. However, the accused, after obtaining bail from the Honorable High Court, appeared before me and I released him in compliance with the bail order of the Honorable High Court. During examination of the victim under Section 161 of CRPC, I came to know that the accused Jagdish Burman kept the victim with him in the hotel, namely Hotel so and so, the Tezpur, giving identity of the victim as his wife. To ascertain the said fact, I have recorded the statement of the managers of those hotels. I have prepared rough sketch of the house of the victim and rough sketch of the house of the victim, whereby exhibit so and so indicates the house of the victim. On appearance before me, I have recorded statement of the accused under 161. After completion of the preliminary investigation, I have handed over the case diary to the IC Lalmati so and so, who after completion of the final investigation submitted charge sheet against the accused Jagadish Burman, finding a prima facie case under section so and so and so. cross-examined. The only line was that victim declined for medical exam. Now, your lordship, 313, these are the only evidence here. No further witnesses are there. So thereafter 313 is there. 313 I will not reach because it is total denial. It's a case of total denial. So there was totally denial on this. Now your lordship will kindly take up the judgment. That is, your lordship starts from page 34. And the original judgments, main judgment starts from 38. Facts of the case, your lordship, I have already mentioned. Points of determination, I'm not reading. I'll come directly to the page 47. Page 47. This is the question whether the victim consented for having physical relation with the accused. Paragraph 15 of the judgment. Page 47. The learned counsel for the accused has argued that the victim was a measure and she had a love affair with the accused and that she was consenting party for establishing physical relation with the accused. The learned counsel has mentioned in his written argument that the evidence of the hotel manager shows that the victim stayed in the hotel with the accused, but the evidence does not suggest that she was subjected to rape or any forceful act on the part of the accused. In this context, it is worth noting that the prosecution case is based on the proposition that the accused obtained consent of the victim girl on the physical relations with him on the false promise of marriage. The allegation is not of forceful sexual intercourse. The evidence of the victim, PW1, makes it clear that initially the accused applied some force, but thereafter she got swayed and the promise of marriage made him, and then she gave her consent. Thereafter, she continued to live with the accused whenever he asked her and maintain physical relation with him. Hence, the case is basically of giving consent under misconception of facts. The victim was under the impression that the accused would marry her. But when the accused refused to sign the documents for court marriage and she received the information that the accused was looking for a girl for his marriage, she came to know that the accused has deceived her. Section 90 of the IPC provides that consent is not such a consent that is intended by any section of this code. If a consent is given by a person under fear of injury or under a misconception of fact, and if the person doing the act knows or has reason to believe that the consent was given in consequence of such fear or misconception. In the present case, the evidence shows that the accused was trusted by the victim and her family members, since he is a distant relation of the victim. He was an unmarried person and was working in the BSF at the relevant time. Hence, when the accused promised to marry the victim girl, she believed him. On such belief, the victim girl even consented to have physical relation with the accused. She did not make any complaint before her family members or anyone else till that time. She came to know that the accused was looking for another girl for his marriage. The evidence of PW1 shows that on so-and-so, she stayed with the accused together as husband and wife at Hotel Uruka for the last time. Thereafter, PW1 brought the relevant paper forms for solemnization of the court marriage, but the accused refused to sign those papers on the pretext that he has some construction work in his house. He also asked the girl to appear in the higher secondary exam and promised that thereafter he would marry her. However, during the continuation of her examination, the PW1 came to know that the accused have taken leave for 2 months, that he was staying in his house at Kusbihar, and that he was looking for a girl for his marriage. This shows the culpable mental state of the accused. These facts could not be rebutted during the cross-examination of the PW1. Just a moment, Your Lordship. Rest, Your Lordship, basically what has been stated by the accused, the victim girl has been quoted here, Your Lordship. So that I have already read the evidences, it's being same thing has been reported here. So I will not read, and I'll straight away go. There are two judgments have also been referred to by the court in paragraph 23 and paragraph 23 only. Lordship will kindly go to and 24, sorry, these two regarding consensual, Your Lordship, part. But paragraph 25, Your Lordship, will come to his decision of the court. That is at page 56.
Yes.
The evidence of the prosecution witnesses as described above no way suggests that the victim girl indulged in sexual act with the accused only because of her love and passion for the accused and not with the expectation that the accused would marry her. On the contrary, the PW1 has candidly stated in her evidence that the accused promised to marry her and on such promise that she continued to live with him whenever he asked and maintained physical relation with him. This statement given by PW1 in her cross-examination, understandably, her evidence which is incriminatory to the accused remain unrebutted. There is a distinction between false promise of marriage and subsequent breach of promise to marry. In the present case, the accused continued in relation with the victim girl until she brought some papers for their court marriage. As soon as the girl insisted for the court marriage, the accused declined to sign those papers on different pretexts, and thereafter he took leave and started looking for a different girl for marriage clandestinely. When his commanding officer inquired about his affair with the victim girl, the accused produced some documents to show that he was already married. This conduct of the accused show that he didn't have the intention to marry the girl from the very beginning. His promise to marry the girl was a false promise. In the statement recorded under 313 of the CRPC, the accused stated that the victim girl persistently asked him to come to Tezpur at least once a month. As such, he once came to Tezpur. This explanation does not appear to be believable. The accused was not a yokel. I don't know what this means. Word. He is a service holder. It cannot be believed that he was compelled by a college-going girl to come to Tezpur to meet her. The evidence of the hotel managers have proved that the accused lived in some hotels with the victim as husband and wife. This shows that he established physical relation with the girl without any intention to marry her. It also reveals that the victim girl consented for physical relation with the accused under a misconception of fact. Now, there was the fact that the FIR was lodged after 2 years. So, here the delay part has been discussed at para 28, page 58. The learned defense counsel has stated in his written argument that there is a delay of 2 years in lodging the Izahat. According to the learned counsel, there is no explanation for the delay. However, this argument seems to be unfounded since the evidence itself reveals that the accused established a physical relation with the victim girl on the false pretext of false promise of marriage. She continued her relation with the expectation that the accused would marry her. However, when she observed that the accused was reluctant to sign the court papers, marriage papers, and thereafter when she came to know that the accused was looking for some other girl for his marriage, the victim informant became conscious of the fact that she has been deceived, and thereupon she lost the SR. Hence, the alleged delay in lodging the SR has been sufficiently explained. It is in the written argument, it has also been stated that the victim informant has given some improvised version of the prosecution story in her evidence. Some of those facts were not mentioned in the FIR, as well as the statement recorded under section 161 CRPC. However, the cross-examination portion of the evidence PW1 revealed that she was not confronted by the defense with her previous statement and FIR since the contradictions, if any, were not proved. The argument regarding contradiction is unfounded. So what has happened? She contradicted some of these statements in FIR as well as 161 and 164 and in the subsequently in the evidence. But the court held that this was not put up at the cross-examination of the victim. So this was remained as proof. In view of the above discussion, it may be concluded that the prosecution has proved their case against the accused Jagadish Burman under section 476, 479. Though charge was framed under 420, the elements of offense under section 420 are absent. There was no delivery of property or any valuable security. Section 222 of the CRPC permits the court to convict a person for a minor offense, although he is not charged for it. As such, accused Jagadish Burman is convicted under section 376 417. Then, Your Lordship, the decision was taken on the sentence that is not required to be read. Ultimately, Your Lordship, page 61, para 35. Considering all the aggravating and mitigating circumstances, the accused Jagadish Burman is sentenced to RI for 10 years and to pay a fine of 10,000 for the offence punishable under 376. In case of default in the payment of fine, the accused shall undergo simple imprisonment for 3 months. For the offence punishable under section 417 IPC, the accused is sentenced to rigorous imprisonment for 1 year. Both the sentence shall run concurrently. The period of detention, if any, undergone by the accused during investigation and trial shall be set off. Now, your lordship will kindly see the 164 statement at page 63.
Page
63.
yes.
Since the last 2 years, both myself and Jagadish Burman are in a love relationship. Since the last 2 years, he kept up saying that he will marry me. On so and so, Jagadish Burman took me to Loyan Hotel near STC Tezpur. He came to Tezpur to meet me. Jagadish resides at Coach Bihar. I took court marriage paper to obtain his signature, but he stated that since he will marry me in the month of May, hence he will not sign the paper. We both are having physical relations since the last 2 years. So and so and so and so, we both stayed in the hotel and we had a physical relationship. I objected of not indulging in any physical relationship with him since we are not socially married, but he assured me that he will marry soon, and so I got involved with him physically. He even assured me that he will marry soon, and so I got involved with him physically. He even forced me to have tablet. On so and so, he put vermilion on my forehead and assured me that by the month of May, he will marry me, and also asked me not to disclose all this to anyone. I heard Jagadish took leave for 3 months for his marriage, but he lied me about his leave for our marriage. In fact, he was planning for his marriage with another woman. I went to his headquarters in Shillong, Meghalaya battalion, but I was informed by the CEO that he is available leave for 3 months for his marriage. I telephoned him and he stated that no action can be taken against him. He and his brother also uttered obscene word to me. He even said to me that if I want to die, I can go for it, and ask me not to telephone him anymore. His brother also told me that nobody can harm them when I call them on so and so. Here, your lordship, the one thing that I want to point out, they state they love the relationship there, and on the basis of the promise, they have had consensual physical relations. That part, your lordship, has been not disproved. But point of rape is not there. There was not a single whisper in 64 that he has forcefully committed rape upon me. So that is what I just want to point. Yes. Then your lordship will. Now, your lordship, nothing much in this. The further paper book does not have all the, your lordship, documents with regard to the hotel register and all are there. That already is there. So I'm not going into this. My case, your lordship, is basically, first and foremost, your lordship, is that the girl is, admittedly, let us forget about the mother. Let us accept her view. Mother said 27, 28 years. We will take it as the 25 years as of the girl, as of her own statement. 25 years, she is a lady who has is not a minor, your lordship. She knows what she is being doing. There may be a promise of marriage which is there or not there. As per her statement only, it can be proved. The mother has not known about it from the very beginning. She said that there may be an affair, and in her statement, she said that the girl used to go on the pretext of visiting her friend's house, go and stay with the accused in hotel as husband and wife. She came to know only after the Azahar was lost. That is one point, your lordship. Because before that, she did not even, if there would have been a rape or forceful something, somewhere or the other, it would have been informed to her mother, but it was never informed, nothing was there. Yes, promise of marriage could be a ground, and they must have had physical relationship. These two parts I cannot deny on the facts of what is there. But the question of rape, your lordship, cannot be ascertained clearly, because nowhere in the evidences specific rape instances has been stated. Then, your lordship, second part is that now the 2 years, that 2-year period, this is not a short period, your lordship. 2 years of period you are having a physical relationship with a person, and if there was a rape, you would have, in these periods, something would have happened. But since it was a consensual relationship, therefore, this is till 2 years, she kept quiet. Only when she came to know that the person is going to get married to somebody else, or maybe she was deceived on that, she lost the. Now, the third point is, Your Lordship, one point that I have said, that she has declined medical exam. Medical examination was also on. So, Your Lordship, rape part could not be totally proved. Only on the statement is there. But other than that, nothing else is there. Now, that is only basis of the, yes, one thing Your Lordship can have, that yes, they had a consensual relationship on the basis of the fact that they are having a FIR or something. But rape part, Your Lordship, may have been added just to make the case stronger or in her favor. That is my case. That much, Your Lordship, but just I would like to point out a few judgments in this regard, 3 judgments. I may reply after my friend says, but as of now, that much is what I would like to point out. There are 3 judgments of the Honorable Supreme Court. First judgment is that Mandar Deepak Power versus State of Maharashtra and others. This is 2022 Live Law SC 649. Here, Your Lordship, is a very short judgment, just 1 page. I'll just read that judgment. That is very short judgment. The appellant and the respondent number 2 were undisputably in a consensual relationship. Same this case, Your Lordship. From 2009 to 2011. Here it is 3 years. It is the say of the respondent 2 that the consensual physical relationship was on the assurance of marriage by the appellant. Similar, Your Lordship. The complainant has been filed on so-and-so after 3 years, pursuant whereto FIR dated so-and-so was registered under section 376-420. Same, Your Lordship, sections were in this case also. On hearing learned counsel for parties, we find ex facie the registration of FIR in the present case is abuse of the criminal process. The parties choose to have physical relationship without marriage for a considerable period of time. For some reasons, the parties fell apart. It can happen both before or after marriage. Thereafter also, 3 years passed when respondent number 2 decided to register an FIR. The facts are so glaring as set out aforesaid by us that we have no hesitation in quashing the FIR dated so-and-so and bringing the proceedings to a close, permitting further proceeding under the FIR would amount to harassment to the appellant through the criminal process itself. We are fortified to adopt the course of action by the judicial view in 2019 9 SCC 608 titled Promote Suryavan Power versus State of Maharashtra. Following this judgment, Your Lordship, I have not brought this judgment, but wherein the factual scenario where complainant was aware that there existed obstacle in marrying the accused and still continued to engage in sexual relations. The Supreme Court quashed the FIR. A distinction was made between a false promise to marriage, which was given on understanding by the maker that it will be broken, and a breach of promise which is made in good faith but subsequently not fulfilled. This was the context of Section 376, Explanation 2, and Section 19 of the IPCD. Criminal appeal is allowed. Here, what I am trying to point out by this judgment was the fact that what has happened, Your Lordship, in this case, she had these physical relations with the person concerned. If there was a marriage proposal, Your Lordship, it would have come to her mother. If there was no more marriage proposal, she should have said that this one person wants to marry me, and therefore, Your Lordship, she would tell her mother that I would like go out with him or stay with him, or I'll go for a pleasure trip somewhere. She has, as per her mother's statement and her statement also, she has deceived her mother by saying that I will go to my friend's place and stayed with the person in hotel in Tezpur itself, where they reside. And if there was a promise of marriage, saying that I am going to marry you, maybe they must have said, but it was not a case where there is a rape, or he must have said, I don't know, that cannot be stated here. But anyways, if that being so, it was a serious decision of marriage between the parties. it would have been discussed with her mother. She would have said it because otherwise she would not lie to her mother and move around. If it was her problem was that you have to marry me. My case here is, your lordship, initially there was no such promises. When they had the affair for a particular period of time, about 2 years and so, then when she started to say that you have to marry me, then he must have said no. Then she made this whole case. This was one. Second part, your lordship, the mother said that she objected to him taking her to Kuch Bihar because he was her mother's, I think, sister married to that person's, the accused brother. So some relation is there. So there was some obstacles there. So that obstacle may also be there because of which the marriage could not also take place. Therefore, she must have lied. So there, I think this whole issue, your lordship, they must have had a love affair, physical relationship. I cannot deny. It is a fact. But promise of marriage, rape, your lordship, is not there. But promise of marriage also, there is a doubt in that. Or even if there is a promise of marriage, then also it was on the ground that at the end of the part, this was must have said that I may marry you, but ultimately it could not happen. That's the case. Now, your lordship will go to the next judgment. That is Mahesh Damu Khare versus State of Maharashtra. This, your lordship, I will give the citation. It is not there. It is a reportable case, so it must have been reported. At that point of time, I could not get the report. Yeah, here I'll go to page para 21. Para 21 is at page 9. 9 is down below. DS group. Below was. Para 21, page 9. Lordship has got that.
Yes.
The complainant had taken the plea that the appellant has physical relationship with her against her consent by making false promise that he would marry her. In this regard, it has to be considered whether making a false promise to marry amounts to an offense. If a false promise of marriage is made to a woman by a man, thus deceiving the woman leading to her engage in sexual relations, it may amount to misconception of fact, in which case the consent given by the woman may be vitiated. In this regard, one may refer to the decision of court in Niam Ahmed versus State NCT Delhi, so and so. The bone of contention raised on behalf of the respondent is that the prosecutors had given a consent for sexual relationship under the misconception of fact, as the accused had given false promise to marry her and subsequently did not marry her, and therefore such consent was no consent in the eye of law, and the case fell under clause second clause of section 375 IPC. In this regard, it is pertinent to note that there is a difference between giving a false promise and committing breach of promise by the accused. In case of false promise, the accused right from the beginning would not have any intention to marry the prosecutors and would have cheated or deceived the prosecutors by giving a false promise to marry her only with a view to satisfy his lust. Whereas in case of breach of promise, one cannot deny a possibility that the accused might have given a promise with all seriousness to marry her and subsequently might have encountered certain circumstances unforeseen by him or the circumstances beyond his control, which prevented him to fulfill his promise. So it would be a folly to treat this breach of promise to marry as a false promise and to prosecute a person for the offense under section 376. In our view, if a man is accused of having sexual relationship or making a false promise of marriage, and if he is to be held criminally liable, such physical relationship must be traceable directly to the false promise made and not qualified by other circumstances or consideration. A woman may have reasons to have physical relationship other than the promise of marriage made by the man, such as personal liking for the male partner without insisting upon formal marital ties. 2023 SCC online so and so. Thus, in a situation where physical relationship is maintained for a prolonged period knowingly by the woman, it cannot be said with certainty that this said physical relationship was purely because of the alleged promise made by the appellant to marry her. Thus, unless it can be shown that the physical relationship was purely because of promise of marriage, thereby having a direct nexus with the physical relationship without being influenced by any other consideration, it cannot be said that there was vitiation of consent under misconception of fact. Now, your lordship will take up paragraph 25. Next page. In the present case, even assuming that the appellant had made the promise since 2008 when they met for the first time, the fact that they remain unmarried for a long period of time, till so and so, without there being any protest or objection by the complainant, does not indicate the intention at the initial stage itself to make the false promise to marry the complainant. Making an allegation of non-fulfillment of promise to marry without undue delay by the promisee would, on the other hand, be an indicator of a false promise being made from the initial stage. In the present case, what is not in dispute is that the physical relationship between the appellant and the complainant continued for a long period of about a decade, and as such, it is difficult to infer that the appellant had made a false promise since the initial stage and continued to make false promises to marry her on the basis which she also continued to have physical relationship with him. Then para 27. Thus, from the above, it appears that it is more of an extramarital affair during the aforesaid period without any insistence by the complainant for getting married to the appellant. The fact that the complainant continued to have physical relationship for a long time without any insistence on marriage would indicate the unlikelihood of any such promise made by the appellant for marrying her, and it rather indicates that the relationship was a consensual one. In our opinion, the longer the duration of physical relations between the partner without protest, the insistence by the female partner for marriage would be indicative of a consensual relationship rather than a relationship based on false promise of marriage by the male partner and thus based on misconception of fact. Next paragraph. Moreover, even it is assumed that a false promise of marriage was made to the complainant initially by the appellant, even though no such cogent evidence have been brought on record before us to that effect, the fact that the relationship continued for 9 years would render the plea of the complainant that her consent for all these years was under misconception of fact that the appellant would marry her impossibly. Consequently, the criminal liability attached to such false promise would be diluted after a long passage of time. In the light of the fact that no protest was registered by the complainant during all those years, such a prolonged continuation of physical relationship without demurral or remonstration by the female partner in effect takes out the sting of criminal culpability and neutralizes it. So ultimately, basically in this case also the also next paragraph, it was very difficult to assume that the complainant, who is otherwise a matured person, here also your lordship, she is a matured girl, with 2 grown-up children. Here already children are there. It is a, in fact, this was a, we are unable to discover the deceitful behavior of the appellant, who continued to have sexual relationship for a long period of time on the promise of marriage. Any such mendicious act of the appellant would have exposed sooner without having waited for 9 years. The inference one can draw under the circumstances is that there was no such false promise made by the complainant to the appellant of marriage by continuing to have physical relations so as to bring this act within the province of section 376, and therefore there was no vitiation of consent after under misconception of that. There's one more judgment, your lordship, the last one, Lalu Yadav. Paragraph totally. Here paragraph 14, 1-4. This judgment is of October 2024. Paragraph 14.
1-4.
1-4. Now, having bestowed our anxious consideration on the decision referred supra, with reference to the factual situations obtained in the case at hand, we are of the considered view that the High Court has palpably gone wrong in not considering the question whether the allegation in the complaint reveals prima facie case that the complaint has given her consent for the sexual relationship with the appellant under misconception of fact as alleged or whether it reveals a case of consensual sex. So my case is this. It is a consensual sex. It's not misconception. Must have developed, but initially it's a consensual sex.
There is no dispute about it.
That
That is
is-
a consensual sex.
Yes.
But the false promise was
False promise part, whether that has come out, your lordship, initially from the beginning or it has come out subsequently, that also I'll come to one of the evidence again to show that it is not that clear. Anyway, then your lordship, firstly, here court has stated how it has come to that. Firstly, it is to be noted that the subject FIR itself would reveal that there occurred a delay of more than 5 years for registering the FIR. Secondly, the very case of the complainant, as revealed from the FIR, would go to show that they live for a long period as man and wife. And thirdly, the fact and circumstances obtained from the subject FIR and other materials on record would reveal absence of a prima facie case that the complainant, respondent 4, had given her consent for sexual relationship with the appellant under misconception of fact. At any rate, the allegation in the FIR would continue a prima facie case of false promise to marry from the inception with a view to establish sexual relationship. And instead, they would reveal a prima facie case of long consensual physical relationship during which the complainant addressed the appellant as her husband. Moreover, it is also the case of the complainant revealed from the subject FIR and the other materials on record that she went along with the appellant to Varanasi with the knowledge of her family and stayed with him in hotels during such visits. The subsequent refusal to marry the complainant would not be sufficient in view of the fact and circumstances obtained in the case at hand by any stress of imagination to draw existence of a prima facie case that the complainant had given consent for sexual relationship with the appellant under misconception of fact so as to accuse the appellant guilty of having committed rape within the meaning of 376 IPC. The long and short of the above discussion is that the case in hand is a befitting case where the High Court should have exercised power available under Section 482 to prevent the abuse of the process of court. Now that the allegation of offense under Section 313 IPC is omitted, there is absolutely no prima facie case for proceeding further against the appellant on the allegation of commission of offense punishable under Section 376. We are of the considered view that the High Court should have exercised its inherent power. For the reasons aforesaid, the impugn order dated so-and-so, High Court so-and-so, dated so-and-so is set aside, FIR so-and-so has all allowed. So here, your lordship, it was stated that normally the facts are similar. Here also she stayed in hotel, went to the place at Kuch Bihar to their relative's house. Now here, your lordship, there is one more line here which was stated was that when the boy took the girl from Tezpur to Kuch Bihar, there was objection raised by the mother of the. So they did not want this to happen. Number two, when they reached place in Kuch Bihar, the statement is there. It says that they have the persons at Kuch Bihar, the relative of the accused, have raised objection of that girl coming to her house, and on the basis of which they called up the mother of the victim, and the mother of the victim then asked the boy to bring the girl back. This shows that there was something, these families were not in connection with having these two persons having an affair with them. After that, this girl lied to her mother and went out to visit her friend on the pretext of visiting her friend, went and stayed with this boy in particular hotels in Tezpur in the area. That was not even known to any of the families. Now that is where the issue, your lordship. Promise to marriage may not have been done at that point of time. If there have been a promise of marriage, she would have told her mother or the persons there that yes, he has promised to marry me, therefore I have come with him. That was never said. So that is where I say that there is something is not clear here, your lordship. She has stated he has promised to marry me, he promised to marry me, therefore I had consensual relationship. Fine. Yes, it could have been like that they had a relationship, a love affair, and after having the love affair for a period of time, he must have said somewhere or the other that, yes, I will marry you, don't have to worry. But ultimately, since both the families were not in, I think they were not agreeable to this type of relationship, some relations are there. Therefore, this could not have happened. And that is why when the girl came to know that it could not have happened, she tried to force the boy to go into a marriage, which ultimately led to breakup, and she filed this. Basically, I find this is because two stories are always there. This is the story done by the girl. This could be found out from the evidences. Both sides do not have very strictly, your lordship, beyond reasonable doubt. It can be proved that there is a rape happened. There is a promise of marriage on the very beginning, and it continued till the end, and he has deceived her on the basis of misconception. She had physical relationship. This, your lordship, very clearly does not, your lordship, prove. So beyond reasonable doubt, this is a criminal trial, your lordship. Beyond reasonable doubt, if it is not proved, your lordship, at least 376 will not come. 420, your lordship, the court said it does not come. Section 420 is punishment has not been given under section 420. It has been brought to 417. Anyway, even if your lordship, taking consideration of the whole facts and on the basis of the judgments of the Honorable Supreme Court, which says that if it is a initially he came and told her that I'll marry you, and after that he has taken her somewhere else and had a physical relationship, it would have been a different issue. But that seems to be not the issue in this case. This is my submission.
Here, my lord, the apparent laws of my lord 2018. And my lord, the date of offense that was my lord for last 4 years now, in the laws of the affair. That is in the my lord concept of that. And accordingly, my lord, the size is changed, my lord, on 25/6/2018, my lord, where my lord, that is the is under my lord, that is 420 and 376. That has my lord come in the search sheet, my lord, that is initiating the affair. And my lord, conviction is also made on 420 and 376. Already my lord senior has my lord submitted my lord all the depositions, the rest part. So I'm not taking so much the time of this court. Here, my lord, the what's my limited understanding is that my lord, there is a regarding my lord the law point, my lord, the thin line. The only the ingredient is that my lord, the part my lord regarding there is a love affair, my lord, from the both the statements of the my lord, there is the prosecutor, and from the side of the my lord, there is the accused, my lord, convicted, my lord, appellant, my lord. So it is very clear that my lord that was there. Now, my lord, who are they, my lord? They are my lord in relation. So they are the maternal aunt of the prosecutor. Now, only the question is that, my lord, a measure while in a my lord relation, only the part is that whether there is a my lord promise to marry is there or not. As a result of promise to marry, my lord, the girl who is in that, my lord, was in that relation with that, my lord. Only, my lord, that part, my lord. Now, my lord, in the, my lord, affair, my lord, if my lord kindly produce the affair once again, my lord, it is the page 4 of the, my lord, that is the book, my lord. My lord, where she stated that, my lord, in the second line, we have been in love for about 2 years and the accused had promised to marry me. So that is the, my lord, what I understand is the main part. The accused had committed rape on me by applying force and defiled my custody. Now the accused is trying to marry another girl. So, my lord, I'm not going to the rest part of the affair. Only the question is that, my lord, there is a, according to the, my lord, that is the prosecuting, my lord, that there is a, my lord, promise to marry me. And then thereafter, my lord, that has happened. Whereas, my lord, this my lord senior's commission is that there is a relation, but that is consensual in nature, and there is no promise. Only that part. Now, my lord, in this case, my lord, that is my lord, the only the prosecutrix, my lord, who is my lord, the my lord is the have that entire the substance of the case, who can only say, my lord, what has happened, my lord. My lord, again I am reading, my lord, both the sheaf and the cross again, my lord. I know the accused present in the dock, so and so. I am the informant of the instant case, and I lodge a written ejahar against the present accused, so and so, at Testu police station. Accused is the brother-in-law of my maternal aunt, so and so. So, my lord, that is the first thing, that they are known to each other, and there is a relation. That is the family friendship is there. There was a marriage of my maternal aunt Protima Roy in the year 2015 and to attend her marriage. Our entire family, comprised of my parents, myself, and my younger brother, went to Coachbehar, and in the marriage, accused himself introduced with him. After stay about 2 weeks at Coachbehar, we returned to our test school. At that time, I was studying in higher secondary first year. Accused somehow collected our mobile number and thereafter made calls over phone, and initially my mother received the call and have talked with the accused, who used to address my mother as Didi because maternal. Thereafter, once accused made call over our phone, and as I was holding the phone, so I received the call, and the accused given his identity as so and so, and I apprised him, and I was available in college, so not in a position to talk with him. Since thereafter, accused started talking with me over phone very often, and thereby a friendship developed between us. Thereafter, once accused proposed to come to Tezpur for a pleasure trip, and accordingly, he came to Tezpur without informing me in the year 2017. After arrival at Tezpur, accused of a mobile phone informed me that has already reached Tezpur and as such asked for assistance. Thereafter, myself accompanied with my friend so and so, but one friend Pinky Ray is there, though she is not my examined. Went to so and so such and such place and brought the accused to our residence. The accused stayed one day at our residence and thereafter proposed to take me to Coachbehar at their residence for a pleasure. Now, my lord, taking the girl to the Coachbehar, in his, my lord, that is when, my lord, same question is put, my lord, to the accused, my lord. He said, my lord, yes, yes, my lord, is 313, my lord, is in 25, my lord, please, my lord. When my lord, the question was put, my lord, that's question number 5, my lord, PW1 also stated in her evidence that after arrival to you our mobile phone informed that you have already in Tezpur and has asked the assistant so that you stayed one day their residence and to take her to Coachbehar. Then his reply was also, my lord, yes, true, my lord, regarding that part. Now, my lord, on the subsequent day, accused brought me to the residence of Tezpur, and then thereafter he returned with assurance not to worry, but he will marry me. At that time, the accused was serving at Shillong, BSF so and so so and so. After a month on such and such date, accused taking a leave for 1 month came to Tezpur, boarded the hotel so and so so and so so and so. Accused given a tablet for the safety measures of pregnancy, and then thereafter kept me in the side of the. Since thereafter, accused very often used to come to Tezpur from Shillong and stayed with me as husband and wife. Thrice in hotel such and such, once in hotel such and such, being the last stay together. My lord, during the course of investigation, my lord, investigating agency, my lord, collected those, my lord, registers of the hotels, my lord. Those are available, my lord. And also, my lord, in the time of, my lord, the depositions, my lord, those were, my lord, the exhibits were, my lord, annexed. And there is no dispute in those parts, my lord, regarding that part. Now, my lord, I took papers from court marriage and asked the accused for solemnization of our court marriage, but the accused, with the pretext he has some problems at this residence, and after overcoming the problem, he would marry me and thereby declined to put signature from the court marriage. At that time, I was reading HS second year, and accused told me to appear for the exam, and after completion of my exam, in the meantime, his house would be constructed, and thereafter he will marry and take me to his residence at Coachbehar. After appearing the higher secondary examination, I came to know over phone that Coachbehar that the accused went to live 2 months and staying at Coachbehar looking for a girl for his. Thereafter, I made calls to the best friend of the accused, who is also a BSF Jawan and was serving in Shillong, and he knew about the relation between the me and the accused. So, my lord, that Jawan is not my lord. from the friend of the accused, it was confirmed that the accused went to the on such confirmation, I went to Shillong, so and so commanding officer, and in this regard, that she went to, my lord, that is the Shillong BSF. That question was also put, my lord, and that here also, my lord, his reply was affirmative. He said yes. In that, when this question is put, my lord, regarding with the complaint. As the accused already married, the CEO advised me to approaching law enforcement agency for taking legal recourse against the accused. Thereafter, I returned to Tesco, lost that. Now, my lord, in the cross-examination, while I lodged the Azahar against the accused, I was about 25 years. At the time of lodging Azahar, I had one so. My mother had her separate mobile. Now, lodging the Azahar, I had one mobile number and my mother had another separate mobile. Now, my lord, because, my lord, the first call was, my lord, came to the home, my lord. And because of that, my lord, this question is put, my lord. And on the date of lodging Azahar, love affairs between me and the accused was the tenure of 2 years and 3 months. There was a well conversation between me and the accused. Because of the accused brother-in-law of my maternal aunt, so with the permission of my guardian, I went with the accused to Coach Behar. At that time, there was a cordial family relation with us and the accused. At that time, accused was serving as a BSF Jawan. I do not know whether the accused visited Tezpur with his official work while posted at Shillong. At first, accused committed rape on me forcefully. Thereafter, he promised to marry me, and on such promise, I continue to live with the accused wherever he asks and maintain physical relations. It is in the cross. As the accused pretended that he has already married before the CO, and so the CO told me that he can ask the accused for payment of money to me as compensation for settlement, but I did not agree to the said proposal of the CO. I informed about the incident of this case to the local panchayat of the accused, but nothing till then. It is not a fact that I have not stated alike of today before IO. Police with medical requisition took me before the doctor for medical examination, but no medical examination was done, followed by a discussion between the doctor and the ladies police official who took me before the doctor. While I tried to give evidence for conversation between me and the accused in respect of our affairs, accused broken down my mobile phone, and as such, the call details were not available with me now. It is not a fact that accused did not propose to marry me, and it is not a fact that I have deposed falsely today. Now, my lord, with my limited understanding, my lord, if I have gone through this cross-examination, this cross-examination, my lord, admittedly, there is no, my lord, there is a medical examination in the part. But it is a, my lord, long continuing offense, my lord, which was continued for a long time. Reason behind, my lord, that is the, my lord, which is the victim, my lord, in her deposition, both in the cross-examination and in seat, my lord, stated that because there is a promise to marry, my lord, and who, my lord, made this promise to marry? It is not an unknown person. For the, my lord, that is the victim. It's a person related to close relative, my lord. So the family she came to know. And because of that reason, my lord, she already, my lord, in her deposition, she stated that, my lord, even her home, my lord, there is a family granted permission to take her to the coast. And in this regard, my lord, in 313, my lord, when this question was put to the, my lord, that is the appellant, my lord, and he said affirmative, that affirmation was there. Say yes. Now, my lord, what is in the 164 statement, my lord, of the, my lord, that is the victim, is in page 63. Once again, my lord, I'm reading it. On note, since the last 2 years, both myself and so in a love relationship, since the last 2 years, he kept off saying that he will marry me. On 21 to 2018, Jagadish Burman took me to a so hotel at Tezpur. He came to Tezpur to meet me. Jagadish Burman resides at so. I took court marriage paper to obtain his signature, but he stated that since he will marry me in the month of May, hence he will not sign the paper. we both are having physical relationship since the last 2 years. On such and such days, we both stayed at the hotel and we had a physical relationship. I objected of not indulging in any physical relationship with him since we were not socially married, but he assured me that he will marry soon, and so I got involved with him physically. He even forced me to have tablet. On 21 to 18, he put vermilion on my forehead, assured me that by the month of May, he will marry me, and also asked me not to disclose all this to anyone. I heard Jagadish took leave for 3 months for his marriage, but he lied me about his leave and our marriage. In fact, he was planning for his marriage to another woman. I went to the headquarters Shillong, so. I informed the CEO that he availed leave for 3 months for his marriage. I telephoned him and he stated no action can be taken against him. He and his brother also uttered language. He even said to me that I want to die. I can go for it. His brother also. My lord, if my lord, there is the 164 of the my lord, there is a 15 my lord. My lord. We find my lord, there is no my lord infirmity regarding the substance of the case. Now, my lord, what is the who is the IO is my lord? That is the PW7. PW7 is the IO. Lastly, my lord, there is the another my lord that is submitted by my lord another my lord. But my lord, the prime my lord is the investigation conducted by the PW7 my lord. My lord in thief my lord. On 22/3/2018, I was serving in the capacity of ASI of Police 19/3/2018, one, the victim name is there, lodged a written ejahat in the OC Tezpur, so receive and register. On being endorsed, I have visited the residence of the victim, recorded the statement of the victim and her mother, and thereafter sent the victim for medical examination by issuing requisition. Thereafter, sent the victim of the court and got her statement 164 CRPC and collected the same from the court. Subsequently, I made the search of the accused to know that at that time he was serving as so-and-so. During the examination of the victim 161 CRPC, I came to know that the accused Jagadish Burman kept the victim with him in hotels, namely so-and-so, giving identity to the victim as his wife. To ascertain the segment, I have recorded the statement of the manager of the hotel. I have prepared the map of the victim so-and-so. On appearance, I have recorded the statement under 161. After completion of preliminary, I have handed over the case and so. My lord, in this case, my lord, that is the 161. I have my lord also produced from there also regarding the substance of the allegations. That is, there is no infirmity in the 161 of the my lord prosecuted. Now, my lord, regarding my lord, as because my lord, some other than my lord, that is the statement of the my lord prosecuted. Now, my lord, rest part, because there is no medical evidence, my lord, available, my lord. Now, the circumstantial evidence, whether my lord, whether wherever he or they were seen, my lord, somewhere together. Now, that is my lord. Because my lord, they, my lord, collected some, my lord, that is the my lord, that is the register. So, my lord, may kindly produce the PW4, my lord. It is in page 17, my lord. PW4. PW4 is one, my lord, Safayatul Islam. So, my lord, in his examination sheet, he stated, my lord, I know accused present in the dock who has lived in our hotel so and so with his wife. The hotel so and so is Hotel Metro is situated in Mojid Road, Tezpur. I was serving as manager of Hotel Metro continuously for 4 years and left the said job only during the lockdown of the nation in the year 2020 because of expiry of my parents in the pandemic. On 3/8/2017, 22/8/2017, I was serving as a manager of the Hotel Metro Tezpur. Today, I bring with me the daily register of the Hotel Metro of the year 2017 in compliance with the court's order. Exhibit P4 is the daily inmate register hotel test code. According to Exhibit P4 daily inmate register, it appears on 3/8/2017 at about 2:30 p.m. one Jagadish Burman, son of so and so, accompanied with his wife Anima Roy, the prosecutor is the victim, came to our hotel metro and asked a room for their stay. Accordingly, I have allotted room number 111 to them and stayed together in the same room for 2 days as husband and wife. So exhibit so and so P41 is the relevant entry on 3817, whereby room number 111 hotel so and so is allotted for stay of Mr. Jagadish Burman and his wife, signature of 20. Well, again on 22/8/2017, 7 p.m. the state Jagadish Burman and his wife Anima Roy came together to our hotel metro Tezpur for stay, and I, being the manager of the hotel, allotted the room number so and so, so and so, so and so, so and so, so and so. Now, my lord, if a person, my lord, came for a first time, my lord, and if he leave, my normal, my lord, it is a general understanding that a manager or the hotel boy, somebody, because they are dealing with many customers, may, my lord, in a memory, they may not able to recall. But again, if somebody again came, and also not, my lord, alone, my lord, along with his wife, my lord, with spouse, my lord, then obviously, my lord, his memory will help. Now, in the cross-examination part, both Jagadish and Anima went together to our hotel, and Jagadish Burman asked for allotment for room in our hotel metro for stay with one Anima Roy, giving her identity as his wife. Both of them given their identity proof, and thereafter the room has been allotted. The identity proof given by Jagadish Burman and his wife Anima Roy were sent along with the inmate register of the particular day of their stay in our hotel to the concerned police station as a record of daily inmates. As Jagadish Burman took the room for stay with his wife, so Jagadish only put his signature in the inmate register. Room number is a double room with attached bathroom meant for stay together for husband and wife. I have given statement before police in connection with this case and similar. Jagadish Burman accompanied Anima Roy, stayed twice, and also stayed one hotel metro test during tenure. Both of them given their identity as husband and wife in the hotel. There is no separate column. Now, my lord, in cross-examination part also, my lord, regarding their stay, my lord, as husband and wife, my lord, that is not disputed. That part is not disputed. Now, my learned seniors, my lord, his submission is there. There, my lord, is a relation, he said, might have a relation or is a relation. Only the parties there, whether it is a consensual, or secondly, whether when there is a false promise to marry is there or not. Now, my lord, in this case, my lord, only the person is the sufferer or who knows the thing. It is the, my lord, the prosecutor herself. In her statement, whether it is 161, whether it is 164, or her deposition before the learned trial court, my lord, there is no, my lord, information. In the, my lord, cross also, my lord, nothing has, my lord, come up. Only on the one part is there, my lord, that there is no medical examination in this case regarding that part. But other than that, my lord, when, my lord, the same question is put, my lord, already, my lord, I have stated, my lord, in, my lord, that is the page 25, my lord, to the accused, my lord. Though, my lord, he, my lord, in many, my lord, questions put to him, he says the no. In many, my lord, questions, that was affirmative. Suppose, my lord, whenever, my lord, this question is put, is 27, my lord, the PW1 also stated in her evidence that on the next day morning, she once again went to Shillong and met your commanding officer and apprised him about the details of the incident acts of you and her, and the CO allowed her to stay there for the night. The CO in the meantime called in you in the headquarters. What do you say? Then his reply was, yes, it is true. These are the, my lord, circumstances. These are the circumstances. Because, my lord, the victim is the sufferer, and my lord, the victim. Next part is, my lord, the why allowed, my lord. If the question is that if a girl is, my lord, went with a person, my lord, so who is that person? This person is not unknown to the family member, because the person is in relation, my lord, from the maternal line. Now, my lord, if my lord may kindly produce the PW2, my lord, the mother, my lord, mother of the, my lord, prosecuted, my lord. In her seat, my lord, but she said only the relevant part. I, my lord, like to complete, my lord. I know the accused person, so and so, so and so, so and so. There was a marriage of my sister Fatima Roy 2015. To attend her marriage, our entire family comprised of my husband and my so and so, so and so. After attending marriage, my sister returned back to our home. Now, my lord, these, my lord, depositions of the mother of the, my lord, victim, my lord, the second para of the deposition, page 12, my lord. That is, my lord, corroborating, my lord. That the same depositions made by the, my lord, that is the prosecutor. Now, my lord, after about 4 months of the marriage of my sister Protima, once accused made phone calls to me and told me that he intends to come to our place. My lord, words may be different, but the phone calls which came, and she stated that, my lord, he addressed her mother as a Didi. My lord, that part is there. The phone call was there. Accused being one our relative, I could not refuse him. After 1 day of making phone call, accused arrived at Tezpur. Accused stayed for the night at our residence. In the night, accused proposed to take my daughter with him to Coast Bihar for pleasure trip. Although I refused the proposal of the accused, but somehow forcefully, accused took my daughter with him to Coast Bihar. From Coast Bihar, my daughter informed me over phone that the family members of the accused became annoyed on the fact of taking her by the accused at his residence. As such, I asked the accused to bring back my daughter. On the 4th day of the accused brought my daughter back to my residence. My lord, this part is admittedly, maybe, my lord, that total description is not there. But, my lord, taking the girl from the, my lord, from the her own residence, with the permission of the, my lord, parent, that part is, my lord, there is no, my lord, informing in that part. After some days, I came to know that the affair between the daughter and the accused was going on, and followed by the relation, they used to talk to each other. My daughter, with a pretext to visit the residence of a friend, used to go outside of our residence on many occasions. Subsequently, when my daughter lodged at police station, I came to know that with the false pretext of visiting friend's house, accused and my daughter lived together in hotel room at Tezpur. I also came to know that accused kept my daughter with him in various hotels, giving my daughter identity of his wife. Obviously, my lord, and my lord, there may be, my lord, that is also it may be also possible, because, my lord, that is the person is not an unknown person, a known person. The victim is a, my lord, major, my lord. She may go, he may not, my lord, disclose. And in her only, my lord, the best part of the testimony which is available, it is, my lord, the PW1, my lord, the victim to herself, my lord, the lodge the FIR. My daughter told me that the accused proposed to marry her, and with the promise to marry, and so and so. Now, my lord, in the cross, my daughter is presently aged about 27, 28 years. My husband is alive, and he is a rickshaw driver. I believe accused being our relative, but if he developed love affairs with my daughter, it was beyond my knowledge. While we went to Coast Bihar for attending my sister's marriage, there only accused come into introduction with us. Accused altogether came twice at our residence at Tezpur. I have not seen my own eyes that accused and my daughter were living together in the only, my lord, PW1 is the, my lord, PW1 is here, my lord. My understanding, my lord, this is the PW1, my lord, that is the testimony. My lord, that is the PW4 is the, my lord, that is the hotel manager, my lord, who is the, my lord, my lord, that is the from the, my lord, that is the register, my lord, which is not disputed, my lord. 2 times they came, my lord, they were present. And, my lord, that is the, my lord, that is the IO, my lord, the initiative PW7 ASI Mr. Hazurika, my lord, who conducted the investigation. And the part is there, my lord, that there are 2 things, my lord. One, my lord, in his depositions, my lord, IO stated that, my lord, there is no medical evidence. She, in her deposition, she stated that obviously medical is not there, but reason is something. So that is the position, my lord. And my lord, this case, my lord, other than my lord, that is the my lord, the theme, my lord. There's no other my lord, the person can my lord state it that my lord whether my lord there is my lord that is the marriage, my lord that is the promise to marry is there or not. My lord. Regarding the other part that there is a my lord love affairs, my lord, is not disputed because when the my lord questions put my lord, that is in my lord page 25, my lord. That is the my lord, the 313, my lord, and my lord, number 313 is put, my lord. In many, my lord, again, in question number 9, my lord, PW1 again stated in her evidence that in the meantime, love affair grew between you and her. What do you say? And his reply was yes, it is true. These things are there. My lord, the race part, my lord, in the my lord, the judgment, my lord, Lion Court, my lord, while my lord, delivering the judgment, my lord, on the accused, my lord, regarding the my lord, law point, my lord, discussed, relying on that. And another pen is there, for my lord, that is the inform. You will address along with the my lord, the case laws. Yes. Uh,
Just raise the legal position. This is a case which falls within the second condition of section. This is not a question of a sexual act being conducted against the will of the victim, but again without her consent. So, for an act to be considered done without her consent, law says that it must be done by a misconception of fact, under a misconception of fact. So, in judgment, which my learned friend had referred to, but not produced, Pramod Suryaban Pawar, the Honorable Apex Court laid down the tests which are to be examined to arrive at a conclusion whether or not there has been a misconception of. So if I just take your lordship to that legal position first before taking your lordship. I'll just refer to paragraph number 18, your lordship. There it has been summarized. This is 2019 9 STP 60. Paragraph number 18. To summarize the legal position that emerges from the above cases, the consent of a woman with respect to section 375 must involve an active and reasoned deliberation towards the proposed act. To establish whether the consent was vitiated by a misconception of fact arising out of a promise to marry, two propositions must be established. Promise of marriage must have been a false promise given in bad faith and with no intention of being adhered to at the time it was given. The false promise itself must be of immediate relevance or bear a direct nexus to the woman's decision to engage in the sexual act. So there must be a false promise, which means false from the very inception, and the promise must have a direct relation with the act. Now, in the three judgments which the appellants were relying upon, they were connected to, admittedly, they were all, the Supreme Court was examining judgments passed by High Courts under Section 480 for quashing of evidence. This is a matter, your lordship, which has gone to trial. The evidence has been examined. Your lordship is exercising the appellate. So, what is the immediate act? There may be a love affair between the parties, but the love affair does not, the presence or absence of the affair does not make the offensive. The offense which is alleged to be a sexual act done without the consent of the victim. So for that, if I may take your lordship just to one portion of her testimony before the of her evidence at page number 9. I'll just read one sentence. So, otherwise, the lordship has already seen the evidence. Just read one sentence here. The second paragraph at page number 9, last sentence of that paragraph.
Yes.
What happened at Coach Bihar on the first night itself? In the meantime, a love affair grew between me and the accused. No difficulty. That cannot be an offense. On that night itself, the accused promised to marry me and forcefully committed rape. So that night itself, on that same night, there was a promise to marry and the sexual act. So there, the immediacy, your lordship, there is no doubt. As per the testimony of the victim, that has not been rebutted in the trial or in any evidence.
As regards your lordship, the intention of this person, of the accused, your lordship, to make a false promise from the very instant, because that is the second criteria which has to be. So there, your lordship will kindly see what are the subsequent facts from the testimony of the victim itself at page number 10. What happened after she came to know that the accused has gone back to his native place and is looking for alternative marriage. The second paragraph on such confirmation, your lordship has that paragraph.
In which?
Page number 10, second paragraph. Because the first requirement is fulfilled, the immediacy of the promise and the act. The requirement now is to show that the promise was false, the very instant.
Yes, please.
Once I'm reading the second paragraph. On such confirmation, I went to Shillong headquarters of DSF to meet the commanding officer of the accused, but I could not meet him because he was not available in the station at that time. As such, I returned to Tezpur and went to the house of my friend so-and-so and stayed there for the night. On the next morning, I once again went to Shillong and met the commanding officer of the accused and apprised him about the details of the incidents to act of the accused with me, and the commanding officer allowed me to stay there for the night. Commanding officer in the meantime called in the accused in the headquarters. The next morning, the commanding officer inquired about the veracity of the fact from the accused in my presence, and the accused produced some fake documents before the commanding officer showing that you had already married someone. Now, it is on the basis of these two facts, your lordship, that the learned trial court has come to a conclusion that the conditions for committing an offence under the second clause 375 is met. And there has been a detailed discussion on the issue of consent, which my learned friend had already taken your lordship to at page number 40. I'll not read the entire thing, just one paragraph in the book. Paragraph number 25, your lordship, page number 56. Because the requirement as per the law laid down by the apex court is that the act must be conducted, act must be indulged in on the basis of the promise and not because of any pre-existing offence. The evidence of the prosecution, I'm reading paragraph number 25 at page number 56. Evidence of the prosecution witnesses, as discussed above, nowhere suggests that the victim girl indulged in the sexual act with the accused only because of her love and passion. That may be a consideration, but it was not the only consideration. Court says that love and that was something that the court took into account. Only because of her love and passion for the accused, and not with the exception that the accused would marry her. On the contrary, the PW1 has candidly stated in her affidavit, in her evidence, that the accused promised to marry her, and as such promise, he continued to live with him whenever he asked and maintained physical relationship with him. This statement was given by the PW1 in her cross-examination. Understandably, her evidence which is incriminating the accused remains unrebutted. So the rest, your lordship, perhaps because otherwise he is now admittedly married, he has said that he is married, he has children, that part is no longer bears relevance. Fact is that whether on the first night at Coach Bihar, there was an act where he promised to marry and then there was sexual act conducted with him. So in her testimony in the FIR, in her statement before the magistrate, as well as in her evidence, there is no material contradiction. So on that ground, your lordship, I would just like to rely on one judgment on how evidence of the victim is to be relied upon in offences under section 370. So this is Wahid Khan versus State of Madhya Pradesh, 2010 2 SCC, page 9. Paragraph number 70. Kindly take a note of the first words that the apex court uses at paragraph number 70. It is also a matter of common law. So as soon as the Supreme Court says that it is a matter of common law, then all courts can take judicial notice of this presumption. So that is the legal position. It is also a matter of common law
that in Indian society, any girl or woman would not make such allegations against a person as she is fully aware of the repercussions following. If she is found to be false, she will be looked at by the society with contempt throughout her life. For an unmarried girl, it would be difficult to find a suitable groom. Therefore, unless an offense has really been committed, a girl or a woman would be extremely reluctant even to admit that such an incident has taken place. It is likely to reflect on her chastity. She would also be conscious of the danger of being ostracized by society. It would indeed be difficult for her to survive in Indian society, which is, of course, not as forward-looking as the Western countries are. Thus, in case of rape, testimony of a prosecutrix stands on par with that of an injured witness. It is really not necessary to insist for corroboration if the evidence of the prosecutrix inspires confidence and appears to be credible. So, from the examination of the evidence, the learned trial court perhaps felt that the evidence of the informant, who is also the victim, was credible and was proved, was held to be proved beyond reasonable doubt. That was the promise to marry, which led her to indulge in that act, and her consent was not freely obtained. It was due to a misconception of. Perhaps the sentence was likely. That is.
Just one more addition to what my learned friend has said. We have already discussed many a times that. So just for the for your lordship's convenience, I want to point out one thing that is at page 8. Again, PW1. One thing my learned friend said, that there has to be an instantly the person at that moment of time has to propose or state that he wants to marry. After that, he commits the offense, so there is an affair also. Here, what has happened? The affair was much prior to that. That is what I'm trying to point out. The lordship will decide on that, but I'm just pointing it out. Page 8. Page 8, last paragraph. Since thereafter,
Yes.
the accused started talking with me over phone very often, and thereby a friendship developed between us. So already it was developed. Thereafter, once accused proposed to come to Tezpur for a pleasure trip, and accordingly he came to Tezpur without informing me in the year 2017. Next page. After arrival at Tezpur, accused over mobile phone informed me that he has already reached Tezpur and as such asked for assistance. Thereafter, myself accompanied with my friend so-and-so went to Kekorapol and brought the accused to our residence. The accused stayed one day at our residence and thereafter proposed to take me to Coos Bihar at their residence for a pleasure trip. On the next day, I went with the accused to Coos Bihar, believing in good faith to be brother-in-law. The parents of the accused live in separate house, whereas my maternal aunt and her husband live in another house at a distance. At night, the parents of the accused went to the house of the maternal aunt Fatima to stay there for the night, whereas myself was kept with the accused in the house where the accused and his parents generally lives. In the meantime, a love affair grew between me and the accused. On that night itself, the accused promised to marry me and forcefully committed rape. So it is not that that part. Yes, he says that he has forcefully committed, but I don't know how far that is true, because later on she did not say that. Initially, what has happened, initially it was phone calls. The person came, the accused came and stayed in their house. He did not come to their house. The girl brought her to their house. He came to Tezpur, then the girl brought her to their house, and since there is a relative, he was allowed to stay in her house. At that point of time, already she is having it. And after that, she went with him to the residence. She did not go to the hotel in Coos Bihar. She went to the house of her aunt in Coos Bihar, and there she stayed in that place. And then she stayed there. Already we are having a love. Then he promised to marry, and he had a physical relationship, and he promised. Now this is the only issue. Second part, your lordship, a little bit of contradiction to that was by the mother. Mother said that she did not allow her to go to Coach Bihar, but they forcefully went. This was not stated. There's this contradiction. And second part is that. And when she reached Coach Bihar, what she said that there was no way in the house, she was allowed to stay with the boy. The mother said that they were objecting to her and called her mother. when her mother, that she has come to Coach Bihar to stay, and therefore she asked the boy to bring her back. This is the little bit of contradiction between the. The only thing, if we take the whole as a whole, the whole, there was an affair prior to that. In the affair, he came and stayed at her place. She went and stayed at her place. Physical relationship was there. Only promise to marry was. Whether he has promised to marry was on genuinely promised to marry, or he did not genuinely promise to marry at that point of time. That is the only issue. If he would have been actually genuinely promised to marry her, maybe. But due to the fact that both the families were not agreeable to it,
Is
he
there
decided
any
that
evidence
could be
to that
because of the
regard?
fact. That is
No,
my.
no. Is
that-
there any evidence to that regard
Yes,
that he
that
was,
is only
he
my.
was really genuinely
Genuinely,
promised
because
to marry her,
in
but
one.
subsequently,
Yes.
if they turn, is
Because
there
he
any
even
evidence?
tried to put vermilion in her.
No,
and
no. Is there any evidence? I'm just asking.
What?
That something had happened, the circumstances was that he could not, he failed to keep his promise. That may be one circumstance.
There could be, but
Genuinely
that
he
is.
may be. Is there any evidence to that?
That is not there. That is what I am trying to. I did not find, but ultimately he meant. Then they did not. In the, I think, trial court, this there should have been some evidence to show why he has not married. There is not a thing. Nobody has. In fact, I don't know the cross examination or where they have not stated anything. None of the parties broke.
Because yes,
Neither
obviously
the
there may be
prosecution
some
nor.
reason
So
for
I cannot.
that he could not marry her. But there is, I didn't find any such kind of
No,
the
exactly,
evidence
your
in that
lordship is
regard,
correct.
that whether there is.
Only from the words I inferred that. That is, that's all you.
We're reserving the.
Obliged.